Good morning. I will call this meeting of the Interim Judiciary Committee to order. Will the secretary please take the roll?
Senator Krasner, Senator Nguyen,
Here.
Assemblymember Cole, Assemblymember Gonzalez, Assemblymember Hanson,
Here.
Assemblymember Marzola, Assemblymember Miller, Chair Scheibel.
And I am here. Thank you. All right. So today we have a packed agenda. We're going to be hearing from a number of different agencies about juvenile justice. And then at the end of the day, we will be hearing from the business law section of the Bar Association. Before we get to our presentations, just a little bit of housekeeping. I want to remind everybody that we did send out that request for proposals or for suggestions about bills that we might want to use our BDRs to introduce, topics for additional meetings. If you didn't receive the invitation to submit a request or suggestion because you're not on our email list, you can find that request form on our website. And I encourage all of you to take a look there for other meeting materials, which are also always on the website. I appreciate all of you signing in. I appreciate everybody, as always, being respectful of our attention and having your phones and laptops off. I'm not sure if I mentioned this in my first meeting, but of course, the members here are using their laptops. That's how we access all of our meeting materials and take our notes and things. So please don't view it as a sign of inattention that we do have some technology up here with us. We try to use it for good and not evil. And I think those are all of the housekeeping items that I had to go over, except that I am going to go a little bit out of order today. I am always happy to adjust the agenda order if presenters have other obligations. I understand that, these meetings can be long and all of us are trying to balance multiple priorities. So a couple of presenters did reach out to me in advance to reorganize our agenda a little bit. So what I am going to do is I am going to start with agenda item number 6B. We'll hear from the public defenders first. Then we'll go to 6A and hear from the district attorneys on juvenile justice. Assuming that they are ready. I did not give everybody an advance notice, so if they're not ready, no worries. We'll figure it out. But my plan then is to go back to number 3 and then take 3, 4, 5 in order, and we will hear and 7 in order, and then we'll hear 8 from the business section of the business law section of the bar at the end. So without further ado, I will invite our public defenders up to the dais to tell us some more about, or to tell us about juvenile justice. Wait a second, I forgot something really important. We have public comment at the beginning of the meeting and the end of the meeting during the interim. So if there is anybody wishing to give public comment here in person in Las Vegas or in person in Carson City, now is the time to kind of come to the table. I don't see anybody coming to the table in either place, so we will go to the phones for public comment.
Thank you, Chair. If you would like to provide public comment, please press star 9 now to take your place in the queue.
Anne Marie Grant, Advocates for the Inmates and the Innocent. I want to bring to the committee's attention a case out of Dallas County, Texas that made national news earlier this year. The posthumous exoneration of Tommy Lee Walker. He was just 19 years old when he was swept up in a racially charged manhunt, convicted on a coerced confession, and executed in 1956. 70 years later, the county finally acknowledged what his family always knew. He was innocent. What struck so many of us was the impact on his son, a man who had lived his entire life under the shadow of a lie that the state created and the state refused to correct. He grew up without his father, and he grew up with the stigma of a conviction that never should have happened. When the truth finally came out, it didn't bring his father back, but it restored something that had been stolen from him: his family's name, his father's dignity, and the acknowledgement that the system failed. That is why Nevada needs a formal process for posthumous exonerations. On behalf of the advocates for the inmates and the innocent, we appreciate Chair Scheibel and the committee accepting our recommendation for consideration. Thank you.
Chair, we have no additional callers for public comment at this time.
All right, thank you so much. That will close public comment for the beginning of the meeting. And now we will move to our presentation from the public defenders on juvenile justice. Thank you so much.
Good morning, Chair and members of the Judiciary Interim Committee. My name is Jennifer Fraser. I'm the Chief Deputy Public Defender with the Clark County Public Defender's Office Juvenile Division. I don't know if I can go first. I have the PowerPoint presentation, and then Ms. Cook from Washoe can finish up. Just to give some background information about our office, our Youth Defense Division currently has 14 attorneys, a team chief, which is me, and then we have 3 attorneys that are dedicated to our certification in juvenile sex offense cases. We have 1 attorney who also handles certifications, and she also has a caseload of our dually involved youth, which are youth who are both in juvenile justice court and dependency court. We have 8 track deputies handling all of our other quote unquote regular cases, which range from felony, gross misdemeanor to misdemeanor delinquency offenses. And we all share specialty court assignments. This is just kind of a brief overview of the system. I know part of our focus today is going to be on certifications and how that impacts us as public defenders, youth defenders. And when looking at this flow chart, the certifications are kind of key right in the center when we have a plea hearing. Before we would ever get to that stage with certification cases, the court has to decide whether juvenile court can retain jurisdiction or if the case would be transferred to the adult system. If the case is going to remain in juvenile court, then the flow chart would continue on. Here are some basic numbers from our office. I know you'll see stats from the district attorney's office regarding the certifications for the entire jurisdiction. These are the PD appointed cases, which are significantly smaller. I would also point out our numbers have stayed pretty similar throughout the past several years. 24, 25 were dead on similar. There are a lot of conflicts in certification cases in juvenile court, just by the nature of juveniles tend to do things together in groups. So we often have a lot of kids who are charged 2, 3, 4, sometimes 5 kids in the same offense. So that necessitates conflict counsel being appointed to those cases. The big focus that I want to drive home today is a concern I see in certifications is and I've raised this issue before every time I come here every other year, the racial disproportionality in certifications. Now I have the stats for the PD appointed cases, but when you look at the number of cases that we have, and when you look at the different representation, I have the 2024 census data for Clark County, putting the Black population at 14%, Hispanic at 32.8, and white at 37.5. But when you're looking at the certification, 63% are Black youth and 26% Hispanic, and then white is 4%. So definitely some stark disproportionality. Similar numbers for 2024, 59% of the youth that we handled for certification were Black, 31% Hispanic, and then only about 2%, or I'm sorry, 7% for white. So when you look at that, and those numbers are pretty consistent from 24 to 25, although it increased for Black youth, it is definitely of concern. Similar numbers, I had the data from 2023 and 2022. Although when you look at 23, Black youth was 44%, and then 2025 went up to 60% or so. So we do have a 20% increase in those numbers as well. Also, what I'd want to point out, I think it's a misnomer, especially there's a specialty court in the adult system. It's called CERT for kids who are transferred to the adult system, and they're under 18, so they don't qualify for a lot of the programs and specialty courts that someone 18 or older would qualify for. And before that program implemented, a lot of people assumed once a youth went into the adult system, that meant they had exhausted all the resources in juvenile court. They've been through the system, they've been to the youth camp, they've been to correctional. But in fact, that's not true when you're looking at the numbers. 52% in 2024 of our certification cases, it was that youth's first petition, more than likely their first encounter with law enforcement. In 2025, we're at 42% for first and second petitions. So I think that's important to note, and why that's important is because that means those youth have never had any interventions. They've never had a chance at rehabilitation in the juvenile system, and then they're transferred into the adult system, and then for all intents and purposes treated as an adult. I think that's also important because when you're looking at, and you'll see the data in the state's presentation about what kind of charges specifically are being certified and transferred to the adult system. And really the focus is all charge-based. But that is kind of the opposite of what our goals are in juvenile court, where the goal is to not just look at what a juvenile or a youth is charged with, but to understand the whole picture, the whole youth. That's what the focus is for rehabilitation. When you look at our sentences and dispositions in juvenile court, they're not based on the charge. The way our statutes are written is that a youth could be have a disposition for a misdemeanor just like they would if they were adjudicated of a felony offense, unlike the adult system where the sentence is directly tied to the charge. So sentences or dispositions are not automatically based on an offense. It's based on evidence-based risk assessments, which identify risk, need, protective factors of the child and their family. And it's important to note that the charge that a youth has does not necessarily drive their dangerousness or risk to public safety, but you have to look at that whole picture. And I think that's why it's important when you're looking at these certifications on first and second petitions. From a defense perspective, the issues I see with certifications, or that our office sees with certifications, is that there's too much prosecutorial discretion as there's a lack of statutory guidelines. The guidelines as they stand today is you have to at least be 14 and be charged with any or accused of any felony offense. It could include first-time offenses, as I just said. And the case law that's guiding the court to decide whether a youth should be transferred is a 40-year-old case. So it's just out of date, quite honestly. And the research is clear that transferring youth to the adult system actually increases recidivism. The focus for certifications, the stated focus is always public safety. But when youth are subject to long criminal sentences, judges don't know how to handle youth in the adult system because they're not as fully aware of youth mental health needs, adolescent brain development. There's significant research that tells us that transfer does not have a deterrent effect and can in fact increase recidivism. There's a seminal CDC study from 2007 that showed us that youth who were tried as adults actually had higher and faster recidivism rates, especially ones with violent crimes. And why those recidivism rates increase is because it impacts the youth's education and employment opportunities, their exposure to criminal behaviors in adult facilities, and dangerous conditions. One goal that our office or youth defense would have is to reduce the number of children certified to the adult system. A suggested reform is to increase the minimum age from 14 to 16. Another suggested reform is to limit the types of offenses that are eligible for certification to violent offenses only. And here's just an example of our current statute 62B390 with just a change in the language to add crime of violence and limiting what a youth could be certified for. Also, when looking at certification or thinking about certification cases, it's also important to think about time and how that relates to certifications and our other cases that we have. As you'll see from statistics that I believe the state has today, you'll see the total number of certifications that the state seeks versus how many youth are actually transferred to the adult system. So thankfully, that means the majority of youth are staying in the juvenile system. But what that means regarding the time that they're spending in detention pre-certification, pre-adjudication, and then post is something that I think this committee should be aware of. When you're looking at that time spent post-adjudication waiting for placement, so that could be placement for a treatment center, placement at Spring Mountain Youth Camp, or a state correctional facility like Caliente or Elko or Summit View, they're waiting for months, sometimes up to 90 days or longer. The cert process, so that pre-adjudication or for regular cases, can sometimes be 4 to 6 weeks. So that's a significant amount of time that youth are staying in detention, and none of that time counts toward anything. In the adult system, for those I know some have practiced in the criminal defense system, know that that's credit for time, but not for youth. And Nevada isn't the only state to grapple with this issue. There was a investigatory report from NPR released last summer talking about the problem with, quote, dead time in juvenile courts throughout the state. The issue is, as we all know, juvenile court is a quasi-civil and quasi-criminal system, so we kind of take a little bit from both. But sometimes that creates problems or unintended consequences. We don't have determinate sentencing in juvenile court. It's rehabilitative in nature. So it's really hard to kind of tick off time off of a rehabilitative sentence. But then that time that they're spending in detention isn't counting for anything and can actually cause some harm. And we also know it's counter to adolescent brain science, which tells us that youth need consequences for their behavior more closer in time to the offense to have a better impact. It's problematic because detention centers aren't designed to be long-term placements. They're temporary in nature. So this can affect recidivism and affect their ability for education, employment. There's not a lot of programming happening in detention because they're temporary. So again, we're not advancing rehabilitative goals for our youth. And it's also extremely costly to keep youth in these temporary detention facilities because of these significant wait times. Some issues that I think could be possible solutions are to set statutory guidelines for a maximum amount, or at least put a time limit in there. Because right now there's no time limit. And sometimes I see in this practice, I've worked in this system for almost 20 years. When you give someone 20 days, they take 20 days. When you don't give them a timeline, then it's even more problematic. An ancillary solution is to create programs in detention facilities to allow youth to begin programming so they can start that rehabilitative process. Another issue that is both tied to certification, but also the overall juvenile justice system, it's more uncommon to have the intersection of certification and incompetent youth, but it does happen. But it just highlights the broader issue of competency for our overall system. And the need for more overall due process protections. Currently, 62D180 does not provide a time limit for how long a case can remain open for a youth deemed incompetent without probability. So this kind of puts them in this procedural purgatory, as the case could essentially remain open for years. The statutes tell us the juvenile court has jurisdiction into 21. So if you have a 14-year-old who's deemed incompetent without, potentially the court could keep that case open for 7 years, which would be much longer than a kid who was competent. And then that child wasn't even able to have their day in court or go forward with trial. When looking at some of our bordering states, Utah, Arizona, and California, all of those have timelines in their respective statutes. I outlined them here in full, but just to highlight, Utah is 6 months, Arizona is 240 days, and California is also 6 months. So what this means is once the court makes a finding, the case can then only remain open for an additional 6 months to not keep that young person within the court system longer than they need to. I think this is something that could certainly help us throughout the state, because I know this issue is not just a Clark County issue. And here is just a kind of an example of how that would change what 62D 180 looks like to add that time limit of 6 months to mirror what some of our border states show. And then just another, I know the chair mentioned the forms, and but another issue was with regard to how we treat firearms in our statutes as opposed to pneumatic guns, treating them the same. Our suggestion would to identify a statutory difference for those, so dispositions could be different, or at least give the court an option to make those different. And that's it for me, so I'll pass it over to Ms. Cook up north.
Good morning, Chair Scheibel and members of the committee. Thank you for giving me the opportunity to speak today. My name is Stephanie Cook. I am a public defender representing youth in delinquency proceedings in Washoe County. I am the chief of our youth defense unit in Washoe County. We are a much smaller division than what you heard from Ms. Frazier in regards to Clark County Public Defender's Office. Currently, we are 3 attorneys, including myself. Our attorneys represent all of the youth that are being prosecuted in our juvenile delinquency system. As all youth are presumed to be indigent, obviously, if their parents choose to hire an attorney on their behalf or we have a conflict, those cases do go elsewhere. However, all 3 of us carry a full caseload, including any youth in which their case may be, where the state may be seeking certification in their case. Additionally, we have 1 investigator for our unit that we also share with one of our felony teams as well as our misdemeanor team within the office. And we have 2 legal assistants who also split time with supporting other attorneys in our office. In addition to providing youth defense, the 3 of us also handle the majority of adult parole revocation hearings at the prison here in Carson City at Northern Nevada Correctional Center. So all of our staff on our youth division have multiple responsibilities throughout the office. And so even though our numbers of motions to certify youth are not nearly as high in comparison to what Clark County faces, because there are only 3 of us, the impact, even if there are, fewer than 5 on average filed per year, does take a lot of time and a lot of resources within our office, given the other responsibilities and the fact that we carry a full caseload of all other youth who are charged in our court. In regards to the issue of certification, I would agree with everything that was presented by Clark County. As you have already heard, our current statute does allow for children as young as 14 years of age charged with or accused of committing any felony act to potentially be certified to the adult court. And once that child is transferred to the adult jurisdiction, all charges that are included within that petition, regardless of the severity of the offense, are also included. as well as if there are any subsequent cases that that child might face, those would automatically go to the adult system, again, regardless of the severity. So it's not just a temporary situation for that child based on that specific case, but obviously has longer term effects and lifelong impact for them. In looking at what we currently have in the Nevada revised statutes, Title V, which governs the juvenile delinquency system, is designed to address what we already know about adolescent brain development, in that children are markedly different from adults. They're not just small adults. Their brains, are still in that developmental stage, and at the time of adolescence still do not have, fully formed frontal lobe, which we see and know from both science, but I think also all of us anecdotally, whether it's personal experiences as parents or observations or experiences that we've had in our professional capacities, or just observations of youth, in the world on our day-to-day lives. We see that children are more impulsive than adults, that they in the moment may not have the ability to appreciate and understand the long-term consequences of their actions. They are much more likely to be persuaded and influenced by their peers. They may be more interested in acting in certain ways based off of what is the current trend on TikTok or other social media platforms, or may be posting videos or photos of themselves doing illegal behavior or inappropriate things based off of a goal of having more likes or shares or views of their own personal social media. Again, not really thinking about the long-term consequences of those actions. Because our juvenile justice statutes are really focused on the holistic approach of providing resources and services to children and their families when they find themselves involved in the legal system. We're not looking at necessarily the specific offense that may have occurred, but also analyzing what their peer relationships are like, what the home dynamic is like, how their education is going, other vocational pursuits that the child might be engaged in. Our court system is uniquely structured in order to address the child and all of the different strengths and weaknesses that may be present, which, as we all know, if we can address some of those root issues, that the likelihood of someone continuing to recidivate decreases significantly. So in addition to what we know about adolescent brain development, a lot of those issues are compounded by what I see in my daily practice, where many of the youth who I represent or have represented have significant trauma histories. They've been victims of abuse or neglect themselves. There's a lot of instability with their families and within the home dynamic, a lot of residential instability. A lot of our youth suffer from cognitive delays or other significant mental health issues, as well as substance use issues. And again, given the nature of our system, the assessment that Juvenile Services completes, and the individualized case plan that is mandated by statute to address the youth when they are being supervised, really, again, puts our court and our system in a unique position to treat all of these issues, again, regardless of what the alleged offense was, what level of seriousness in terms of, misdemeanor, gross misdemeanor, or felony, to really address all of those issues. So in addition to what has already been presented in terms of raising the age, providing guidelines as to what types of offenses should even be eligible for certification. I think another legislative change that could be helpful is to include a rebuttable presumption that a minor's case should remain within the juvenile court. Again, because the partnerships that we have with community providers and the knowledge, specialized knowledge about brain development that our courts have and our system partners also have, provides us the opportunity to wrap services around the children and families when they need it in a much different way than sentencing someone to a term of prison years in which they're not going to have the same access to educational services, mental health services, substance abuse services, vocational training, and the like. I would also state that, even though I know that this is not a money committee, one of the issues that I think everyone can agree on both sides of the aisle is that part of the concern or issues that we face in the juvenile court, which I believe, everyone faces, is that the resources that we know statistically and evidence-based practices that are proven to have the desired outcome in terms of providing the necessary rehabilitation and reducing recidivism just don't exist to the level that we need them to address the issues that we are seeing in our community. If you look in Washoe County, for example, we do not have access to an inpatient residential treatment facility for children with substance use disorders. And so, we might have children, or we often have children who have significant substance use issues, whether it be with alcohol or controlled substances. And unfortunately, we just don't have that resource within our community to treat that issue. Similarly, with significant mental health concerns, we have very few community-based resources and providers, especially when we are dealing with populations who are in poverty or near on the fringe of poverty without, private insurance that opens up a lot more doors for potential access to treatment providers, facing long wait lists. One of the things that was mentioned in the earlier presentation was the time that a youth might spend in a detention facility awaiting evaluations, even to identify what the necessary treatment modality should be. And that is also a resource issue in terms of the limited number of providers with whom Juvenile Services has contracts with to provide those evaluations. So sometimes we have children who are sitting in custody for a month before they're even evaluated, and the time it takes to get that full evaluation to even send out referrals does take a lot of time. We also know that the Department of Justice has come down in the past on the state of Nevada in the fact that we send so many youth out of state, outside of their community, to receive the necessary treatment, and then upon return, whether the recommended step-down treatment at the time of discharge is available and accessible to them in a timely fashion. And so I think another way to alleviate maybe some of the concerns about community safety and the dangerousness of some of these younger offenders would be to appropriately fund the resources that are necessary in order to address a lot of these issues. We see here in Washoe County that a lot of our more violent offenses are oftentimes gang-related, and we do not have any sort of specialty court or diversion program or specialized program specifically to help divert youth out of the pathway toward gang affiliation or association or membership. And then once a youth is entrenched in that gang lifestyle, we have no specific programming to help extricate them, whether that is working with community partners, whether it is the opportunity to expand what juvenile services here in Washoe County has already started in its multi-systemic therapy pilot program, which has been evidence-based to assist with gang-involved youth. However, again, the limited resources and funding that we have for that program just is not something that we have available as a resource because we use it for more than just gang-involved youth, right? We have children who have significant mental health needs and, their parents need additional support. And so if we were able to have more resources in place, we do not have here in Washoe County either any sort of specialty court programs in our youth court. So we don't have access to a drug court or mental health court or other things that could provide, again, more structure and support, not only for the children, but also for their families. Because, again, we have parents who oftentimes are struggling themselves, whether it's with the fact that they have multiple children that they have to care for as a single parent, or they have to work long hours just to make ends meet, transportation barriers just to get to and from different appointments or check-ins with probation, as well as just the financial barrier in terms of accessing services or not being able to take time off of work because if they're not at work, they're not getting paid. And so, unfortunately, making the choice of, being able to make the rent and having a roof over your head or taking time off of work for a half a day to get your child to their various classes or therapy appointments. So again, I would urge the committee to consider a lot of the reforms that were already mentioned, specifically related to the certification process, not only raising the minimum age, eliminating those, the discretion in terms of what type of charge could be certified, and then again, creating a strong presumption in favor of retaining jurisdiction in the juvenile court. I think that, the biggest issue, like I said, is expanding those resources within the juvenile system to account for those more serious offenses, so that those people who are best trained and the structure that is best suited to address holistically where the child is at and what they need can be done in an effective manner. I would also echo what has already been noted in regards to the credit for time served issue. I will note, however, that our juvenile services department has been working diligently to provide more services to youth who remain detained as they see the need for, as some of the detention times have gotten longer and longer in recent years, wherein some of the youth development programming and therapeutic services are offered and available to youth who remain detained. I would also believe that another way to address some of the time delays in detention, would be to draft legislation to creating a deadline for in-custody evaluations similar to what is currently contained within NRS 62C.060, which requires if a youth is arrested for possessing a firearm on a school campus, that they must be evaluated by a qualified professional, and that evaluation must be completed within 14 days. So again, I think putting a timeline and pressure on the system will assist in making sure that these delays that we are seeing, especially from our community providers, that if they know that they're under those time frames, that hopefully that would increase our access to evaluations and getting that information back as soon as possible. I also would support the legislative changes proposed regarding incompetent youth, as well as the difference between a firearm versus a pneumatic gun as well. As I see that both of those issues are relevant to the youth that we represent and the types of cases that we see. I believe that those proposed language changes would address our concerns in relation to those issues. Again, thank you very much for your time this morning and for accommodating my schedule to take us out of order.
Thank you both so much for your presentations and all of that really helpful information. I think we do have some questions from members here. So I will start with our members here in Las Vegas. Senator Nguyen, go ahead.
I have a couple of questions that went back to some of the original slides from the Clark County Public Defender's Office. When you were talking about some of those timelines, I think it's I just want to clarify. Right now, there's nothing like, for example, if you're an adult and you're charged with a misdemeanor, the maximum sentence is 6 months. So if you are awaiting and you start approaching that 6 months of time of being in custody, a lot of judges become very aware of that, and prosecutors become aware of that, and obviously defense attorneys become aware of that, and all of a sudden you're released because you're serving more time than your sentence actually would be if you were convicted. So could you just hold someone indefinitely until they are adjudicated of whatever, I guess, infraction or civil disciplinary charge?
Thank you for the question, Jennifer Fraser, for the record, JENNIFER, FRASER. I'm sorry I did not spell at the beginning of my testimony. Are you talking for the youth who are waiting correctional placement, so not the incompetent, or both?
We'll start with the people waiting.
Yes, so
Their adjudication.
your question is correct. If a child is adjudicated, say, of a misdemeanor battery, our statutes are written so that the judge has the discretion to sentence, or what we say have the disposition be placement at a correctional facility. So if then that youth is approved for, say, Caliente, they could be waiting. Like if the case took 2 months to get from initial appearance to trial, and then waited a couple weeks for the R&D hearing, which is the sentencing hearing, and then waited for 90 days, right then you're already at 6 months, which would normally be it for if you're an adult, but for a child, there is no limit. So to your question, there's nothing in the statutes, to my knowledge, that would limit that or allow us to go back and say, oh, he's already served that time of sentence, because it's indeterminate, so there isn't any.
Is this typical when it comes to these juvenile dispositions across the country, or do other people have set time limits, or I don't want to,
Sure.
for all intents and purposes, sentences?
Yes, it's mixed throughout the states, throughout the country. Not every state has indeterminate sentencing. I know that article from the NPR highlighted that it is an issue that all of the states that have the indeterminate sentencing are grappling with and are making legislative reforms. I know Washington, D.C. and Baltimore are focusing on that because of the issue that it arises. And then when states have budgetary concerns and there's less beds and things like that, then that just adds on to more time and affects the youth in the juvenile systems.
And then kind of shifting over to the other half of that when it comes to children that have been deemed incompetent. Mm-hmm. And so they haven't been adjudicated, or there hasn't been any kind of conclusion, I guess, to their initial charges. In the adult system, obviously, there are some timelines which we are obviously not complying with on the adult side as well, but so there are no timelines in statute or no timelines in case law? Has it ever been adjudicated? Has anyone ever taken this up?
To my knowledge, for case closure, no. We have a statute that allows for us to seek under 62D 180 and the associated statutes to request the court to dismiss the case based on a number of factors. But again, that still lies with the court to have jurisdiction to keep it open. One of the factors could be like risk factors. As we know, these youth struggle with significant mental health issues. A lot of them are dually involved or in the DFS system as well. So their risk is never going to be low and is never going to satisfy those statutory guidelines. So the court can keep those up. Keep those cases open. We were initially struggling, as this committee might be aware, with just finding a forensic unit for those kids who are struggling and need the restoration treatment. Just last summer, Desert Willow opened up a wing to allow those kids to go there. So that was kind of our struggle, was just making sure we could get our youth out of detention and into that facility. And so now I think that we've successfully, thanks to this legislative body, been able to do that. Now our focus is on, okay, now that we have that first step where we have youth who can go for restoration, now what happens with our clients who are never going to be restored or never going to, and what are we going to do with that? So right now we don't have a case that we've taken up. We've just highlighted that this is a significant issue.
So that kind of maybe answers my next question. Do we have all of our children that are incompetent or pending competency, like restoration? Are they all being appropriately housed, or do we have children that are being housed still in a detention facility after that determination that they are incompetent?
Jennifer Fraser, for the record, now that the unit has been open at Desert Willow, the youth are appropriately being moved from detention to that facility.
And is that happening timely, or do we still have do we have children that are commingled with other youth offenders with incompetent children?
Jennifer Fraser, for the record, that since that unit has been opened, we haven't had the issues with the timeliness. Once we get the evals, and we have to follow the regular process of making the ask of the court to find our youth incompetent, get the evaluations, but we're not having that wait times that we were having before, where youth were staying in detention for months and months.
And up north, are we having any of those issues up north?
Stephanie Cook, for the record. In regards to competency issues in Washoe County, the large majority of our youth who have been deemed incompetent, or where there are competency concerns raised by one of the parties, are already out of detention. We do have one client who is currently housed at Desert Willow undergoing that restoration process. But one of the findings that the court makes at the time of determining a youth to be incompetent to proceed is whether or not that child can be treated on an outpatient basis, or whether they are so dangerous that they need to remain in a locked facility. And like I said, we only have one youth currently in Washoe County who has remained locked. Like I said, the majority of our incompetent youth are out of custody. One of the issues that we have is locating appropriate restoration services. It's been difficult for us to treat youth, or attempt to treat youth to competency on an out of custody basis. Again, just a resource issue that we are confronted with. And then, the statute also does require that there are regular review hearings after a competency determination has been made, a finding of incompetency by the court. And so we are oftentimes in front of the court to, one, see if other treatment modalities have sufficed to alleviate any concerns, and or whether the child has been treated to competency to proceed. And again, as Ms. Fraser did indicate, going through those factors contained within statute to determine whether that child's case should continue to remain open, or whether we are at a point where the parties are satisfied and ultimately the court is satisfied that the case can be dismissed.
So you had kind of mentioned this before. Is it and forgive me, I don't know. Is it a similar circumstances like with adults? Like if there is a determination that someone is incompetent without probability, is there a similar statutory, I guess, language for juveniles? Like, I know in the adult system, if you're incompetent without probability, the case is dismissed, but we have people that are committed, I guess, civilly, potential, with those reviews. But how does that work in and do you have any of these children?
Jennifer Fraser for the record. We have had these children over the years, and the Council for the Youth and the state and the court kind of have like worked together, kind of really worked outside of the box and figured out a plan. And ultimately the case will get dismissed essentially by a stipulation of all parties. We don't have a statute that says it has to be dismissed. It says we can request dismissal, but again, it's up to the court based on several factors. So we don't have an automatic right to that. Or our youth, our clients don't have an automatic right to that, like some of, because I was curious about that when I was looking at the bordering states. All of them made it very clear and set strict timelines, and didn't leave it within the discretion and did not leave it within several different factors for the court to consider. To simply put, after 6 months, if there's no chance of probability, the case needs to be dismissed. And we currently don't have that.
Is it just kind of a hodgepodge around like surrounding states or around the country, or is there best practices around this?
Jennifer Fraser for the record. I'm trying to remember, when I was looking at the state legislature website and was looking, I stuck to just the states bordering us. So I don't have an answer. I can certainly look into that because I am interested, just for our own practice of knowing if we're an outlier or not. But as far as like our bordering states, we certainly are.
And this probably isn't a question for you, but I know that in my practice, like having been in this like field, when juveniles are certified up as adults at like as young as 14, they now go into the hands of like adult defense attorneys and other circumstances of detention, and while they're temporarily isolated until they turn 18. Have you had any other conversations with law enforcement partners or anything about their abilities or inabilities to be able to house the growing number of juveniles that have been certified up as adults?
Jennifer Fraser for the record. I know that's always a discussion, especially if there's an increase in numbers. There's always a discussion too when it comes to females who are certified, because there isn't a designated wing. For young boys who are certified to the adult system, there is a wing or a pod within CCDC for kids who are under 18 so they can have more access and more programming. So that's a positive thing. I don't believe they have that for girls. The numbers of girls certified is far, far less. It's one every now and then. I think currently there's only one female underage. She might have been turned over 18 by now. That was at Florence McClure. So it's not a significant number, but it's still an issue. And then that young girl is then even more isolated. And that's the issue, yes. So I know there are concerns from the minute a child crosses that threshold from going to the adult system, because all of a sudden they're treated as an adult for purposes of their case and jurisdictionally, but then have none of the other rights or protections. You still, for instance, if a person who is 16 gets certified and is able to make bail, CCDC still can't just release them like they would another. They have to have their parent come pick them up. So there's all these like added issues with when a child is transferred to the adult system, from the minute they step into an adult facility to the programming offered to probation to unfortunately for some of those youth who go to prison. Thank you.
Stephanie Cook for the record. In Washoe County, we do not again, we don't have the same number of youth who end up being transferred to adult court. We have had some success working with our Department of Juvenile Services, in which a large percentage of our youth who have been transferred to the adult system are able to return to our juvenile detention facility until they turn 18, so long as they are following the rules and don't pose any additional security or safety risks. But unfortunately, if that is not able to occur, or they end up being housed at our Washoe County Regional Detention Facility, the jail, we don't have a designated wing through the sheriff's office specifically for these youth. And so oftentimes they are housed in the infirmary because the Prison Rape Elimination Act requires them to be separated from sight and sound from anyone over the age of 18. So they are effectively kept in solitary confinement in the infirmary with their window closed so that none of the other inmates would be able to see them, so that the youth wouldn't be able to see out to any adults who are currently incarcerated. And then just anecdotally speaking, the infirmary is one of the most hectic places, I would say, in our Washoe County Jail in terms of loud banging, screaming, yelling. Most of the adults in that facility are suffering from significant mental health issues and or are on suicide watch. And so, as you can imagine, it's not a very a good place for anyone to be in. But if you are forced to be there for the entire duration of the time that you remain as your case is pending, dealing with that day in and day out. And again, like I said, effectively in solitary confinement, just because they cannot commingle with the adult population. So that additional detrimental effect on mental health and emotional well-being.
And I know I said I had no more questions, but I have one more question. I know that one of the struggles that happens when children are certified up to as adults is they don't qualify, like you had mentioned, they're in that in between. Like if they can make bail, they can't get bail because they have to be released to a parent. So they're kind of in that in between world where the court is treating them like an adult and the jail system is treating them like a pseudo adult. But then they don't qualify for all the things that you would need, like they wouldn't be able to go into a boot camp, or they wouldn't be able to go into drug court. They wouldn't be able to qualify for diversionary programs that if they were 18, they would be able to. Do you know if there have been any programs that have been instituted? We have specialty courts. Are there any like mental health specialty courts or other types of like programming that might be able to keep juveniles in the juvenile court where they might be considered for, I guess, certification? Like, are there, I guess, programming that's like more juvenile, like centered to avoid some of that? Or have we just not had that kind of collaboration with prosecutors in that space?
Jennifer
Yeah.
Fraser, for the record, there is a new, all relative new, probably a year old now, specialty court in the adult system for kids who were certified. And that was the whole goal. Judge Bluth and Judge Schwartz started that program. It's called CERT. CERT, and the goal of that was those judges recognized that it was incredibly difficult to have a 15 or 16-year-old standing in front of them, and the state or probation asking for that youth to be sent to prison. They wanted to be able to give them a chance, but then had all those roadblocks of like, you can't do drug court, you can't do mental health court, you couldn't even do open, which is the young offenders program. So they created this, partnered with a in-community mental health provider, at one point had possible alternative placement like residents, and drug treatment, all of those things, and works really closely with the family. So that has been going on for about a year. There's only been 3 participants. And there's currently 1 participant. I handle that court along with Mr. Watson, who you'll hear from later today from the state. Our current participant is doing very well, knock on wood. So I think the idea behind that program is great. And I really appreciate the judges recognizing that. They even went to the prison up north to talk to the kids who went there and ask them, like, what did you need? What was not, how was probation so difficult? Because that's also the thing, people who are 18 to 25 struggle on probation, that emerging adults, so even younger kids can't handle. It's just difficult for them to be on adult probation. So I do appreciate that program. That being said, all of those services that are being offered once they're there in the adult system are services we already have in juvenile court. And so I would be remiss if I didn't point out that it would, for youth, and when we know about recidivism and public safety, that those kids should be given a chance to have those services in juvenile court before being escalated to the adult system. But I do appreciate for the kids who are there that have that option. Thank you.
Other questions from members here in Las Vegas? Not seeing any online or Carson City. All right. I think actually Senator Wynn covered my questions as well. So I really appreciate you being here and providing us with that information. At this time, we'll move on to our next presentation. All right, it sounds like we have our district attorneys in the hopper, and I will open it up for you guys whenever you're ready.
Thank you. Good morning, Chair Scheibel and members of the Interim Judiciary Committee. My name is Michael Watson, M-I-C-H-A-E-L-W-A-T-S-O-N. I am a Chief Deputy District Attorney and the Team Chief over the Delinquency Division in the Clark County District Attorney's Office. I've held that particular position for over 8 years, and I've been in the Juvenile Division since 2010. Joining me in this presentation today is Ben Newman, Chief Deputy District Attorney in the Washoe County District Attorney's Office, and Bridget Duffy, Assistant District Attorney over the Juvenile Division in Clark County. We're here to discuss these certification cases and numbers with you. Certifications are a transfer of the jurisdiction from the juvenile court to the criminal or adult court. This transfer does not happen automatically. NRS 62B requires the district attorney's office to request the transfer by filing a motion with the court. The statute then requires a full investigation, and in both jurisdictions that requires either the juvenile probation or parole department to investigate and prepare a report for the court, as well as a psychological exam and report and drug testing. Both sides are provided with these materials, as is the court. We argue our positions, and ultimately the decision of whether to certify the juvenile lies with the juvenile court judge, and their decision is discretionary. Rule 33 in Washoe County, they have a local rule, Rule 33, that requires a motion to certify be filed no later than 30 days after a petition is filed, and that a hearing is held within 35 days after the entry of order for the investigation. Clark County has no such rule, but as a matter of practice, we have plea hearings set 72 hours after a detention hearing. The juvenile then enters an admission or denial at that hearing. Pursuant to 62D 020, juvenile are prohibited from being prosecuted for the same offense in a criminal proceeding after the juvenile court accepts the juvenile's admission. So as a practical matter, we have to file our motion within 72 hours. The statute allows for any offense that would have been a felony if committed by an adult, if the juvenile was 14 years of age at the time of the offense, to be certified, or any murder or attempt murder if the juvenile was 13 to 15 years of age at the time of the offense. But we don't seek it on just any case that fits that, and we'll talk about that later when we get to our stats. As mentioned previously, the court has discretion to grant or deny the motion to certify. And then the case law that we have, which is 40 years old, does create a presumption already that the juvenile court keeps the juvenile in the juvenile system. This presumption can be rebutted by a showing of clear and convincing evidence, which is our highest civil standard of proof, that public safety requires the transfer to the court system. In order for a court to make this decision, the juvenile judge first has to make a finding that there is sufficient evidence to warrant the case having prosecutorial merit. If the court does make that finding, the case, or does not make that finding, the case would be dismissed. However, if the judge makes the finding, then they move on to a three-pronged decisional matrix. The first prong of that is the nature and seriousness of the offense. The second being the seriousness and persistency of the juvenile's prior admissions or adjudications. And then finally, the court will look at subjective factors to see if they outweigh those first two prongs. Subjective factors, just some examples of this, it can be really anything that the court wants to consider. Often it's the age of the juvenile, any family support or lack thereof, their behavior in the home, community, school, any prior services they may have received in the juvenile system already. And then those previously mentioned evaluations come into play here as well. The court looks at any substance abuse findings there, any psychiatric diagnoses, etc. The court takes all this together and makes a determination, again, within the judge's discretion, if there's a showing by clear and convincing evidence that public safety requires a transfer to the adult system. So that was a crash course in juvenile certifications and what we're looking at. However, this here is the type of felonies where the Clark County Attorney's Office is seeking certification. So these are where we've filed the motion. These percentages are based off where we filed, not where it was granted. And in 2025, 6% of those cases were murder and attempt murder cases. Robbery where a firearm was used made up 51% of the cases. Any felony level discharging of a weapon, so this is like you're discharging a firearm into a structure or from a vehicle, so basically drive-by shootings, which we have seen an increase in Clark County over the last couple of years, made up 16%. Battery with use of a deadly weapon resulting in substantial bodily harm. And I looked at each one of these cases, and for all of them that year, that was a case where someone was actually shot, but did not qualify for attempt murder. That made up 7% of the cases. Felony cases where there was a significant prior history or certification or a prior certification, basically cases where we just felt we had already exhausted all the resources we had in the juvenile justice system, made up 9%. Other felony cases resulting in death, so DUIs, reckless driving resulting in death, made up 2%. Other felonies were just based upon the facts of the case. When we read them, it was something that we felt needed to go to a court to look at it within their discretion. So terrorism cases, cases involving large hacking groups, and other cases forwarded to us by the FBI. Finally, felony cases or sex cases where, based upon the facts of the case, they were so egregious we felt that that needed to go to the adult system, or at least for a juvenile judge to look at it and determine whether it should go to the adult system, made up 3% of our cases. So as you can see here, what we're seeking certification on really is violent cases. Our stats for 2024 and 2025 I have here. First, let me preface this, and this should apply to the last slide as well. For all of these numbers, the Clark County District Attorney's delinquency team does not have its own case management system. So I rely on our juvenile justice partners to get numbers from their system, as well as with these certification numbers. We do keep track with a spreadsheet within our office. So I have to hand tally each one of these cases. For all these numbers here, I looked up each individual case for that year as far as the certifications. As you can see, in 2024, there are roughly 8,900 referrals to the entire juvenile justice system and approximately 3,100 petitions filed. So about 35% of the cases referred to the juvenile justice system, we filed into the court. 197 of those cases, we sought certification asking the court, and that was made up of 177 individuals. So just 2% of the cases. The reason the difference with the individuals versus the certification numbers is some individuals may have more than one case at a time. We argued only 61 of those certification cases. So only 34% of the cases that we sought certification, we actually took to the judge. The rest of them, after we received the full investigation, the psychological reports, we reevaluate the case and we make a determination whether we will withdraw our certification and keep them in the juvenile system. So 66% of our cases we are withdrawing and using our discretion before turning it to the judge. Of the 61 that were argued, 44 individuals were certified, so 25% of the cases, and that's only 0.5% of all referrals to the juvenile justice system. Again, the numbers in 2025 here you can see are very similar. There's a slight increase on the overall numbers, but the percentages are virtually the same, ending up with 24% of the cases where certification was sought ended up in the adult system, and only 0.5% of all referrals again. Just reiterating on that year, we withdrew 70% of the cases after we received that full investigation. And then here is a look at a breakdown of the juveniles that were certified in 2025. Of the cases that we argued, 79% of those cases were granted. I only point that out because the courts are not just rubber stamping these decisions. When we put a certification in front of them, they are reviewing everything and determining whether or not they're going to place a juvenile in the system. So their discretion is working. 30% of the cases where we sought certification or where they were granted, were 18 years old at the time the certification was granted, and another 10% were within 2 months of being 18 years old. So the majority of them are on the higher end. And then there's the full breakdown of the number there. 18 years old make up 30%, 17-year-olds 42%, only 16% at 16. And then by the time you hit 15 and 14-year-olds, it's only 8%, 4%. And we had no 13-year-olds for 2025. 72% of the cases where they were certified were murder, robbery with a firearm, those discharging drive-by type cases, and battery with use of a deadly weapon resulting in substantial bodily harm. So the vast majority are those cases where there is violence involved. And then I had the opportunity to look up each one of the cases in the adult system. I was surprised to see that the majority of the cases were already sentenced. I didn't think that would be the case, but the vast majority of them were. And only 12% of those were sent to prison. So there is this perception that when we certify a juvenile, they're going to prison, but that's not what the numbers show. There's actually an opportunity for them on the adult side for adult probation and specialty courts. For those that are 18, we do have the open program, and the majority of them by the time they get to sentencing are 18. For those that remain under 18 years of age, as Ms. Frazier pointed out, there is the CERT program that both of our offices staff as we understand those youth best. And that it was a situation where Assistant District Attorney worked with Judge Bluth and Judge Schwartz to create this program. So we are trying to make sure that there are options for them on the adult side. And if they're able to complete that, they would actually have their case dismissed. So those are our numbers for Clark County. I'm now going to pass it to Ben Newman in Washoe County to go over their stats.
Good morning, Chair Scheibel and members of the interim committee. My name is Benjamin Newman. I'm the Chief Deputy District Attorney for the Juvenile Division for Washoe County. I've been a juvenile lawyer for about 12 years and been working for Washoe County in that capacity pretty much the entire time. I just want to highlight that we are a substantially smaller outfit than Clark County with regard to case numbers, staff. We have 3 deputy district attorneys that work in the juvenile division and are currently down 1. So right now there are 3 total. Typically there's me including 3 others, so 4 total, and we all have active caseloads. I just got to a number of stats for the year 2024 and 2025 to highlight who and when and the numbers of people that juveniles we do certify or file motions to certify on. And in the year 2024, we had a total of 1,554 referrals. We had 1,225 total petition requests. Sort of a side note, the reason that those two don't match up is oftentimes a petition request has a multiple number of referrals. A referral is an agency case number associated with a citation or a police report. And typically, or oftentimes, juvenile service will send one over with multiples on there, and it will result in one single petition. With that, we had filed 825 petitions, kind of another way of explanation. Inside of the total petition requests, 825 is 400 or so less. We have programs, memorandums of understanding we have worked out with juvenile services, send cases that we don't believe petitions or formal probationary supervision should be had. And so we skim off a number of those. I don't have those stats right now, but we skim off those to engage in less than petitions in court involvement. Out of those 825 petitions that we actually file, for 2024, we filed 4 motions for adult certification. Of those 4 motions, 2 were granted. 1 is currently pending as the young person was deemed incompetent. A look at that number is 0.36%, which is about 1/3 of 1% of the 825 petitions that we filed motions for certification on in the year 2024. With regard to 2025, you see similar numbers. We had 1,441 total referrals, 1,150 petition requests. The state filed 756 petitions, and again for this year, that year we filed 3 motions for certification. We had withdrawn 1 of those motions, 1 of them was granted, and 1 of them is currently still pending. That is a little bit over 1/3 of 1% file rate, and actually pursued is less than 1/3 of 1% of our total petitions filed. If I can get the next slide, please, Michael. When and who Washoe County certifies in the breakdown. For the math, that's 6 people that the state had certified or filed motions to certify in those 2 years, 1 of which was withdrawn. So there's 5 potential pending motions. 2 were still pending and 3 were granted. Of those numbers, 33% of those juveniles were for murder. 33% were for attempted murder, and those charges inside of attempted murder included battery with the use of a deadly weapon, battery, substantial bodily harm, and assault with a deadly weapon. 16% of those motions were battery, deadly weapon, substantial bodily harm, and another 16% was battery, substantial bodily harm without the use of a weapon. That was the case the state withdrew. 33% of the motions filed were for 17-year-olds. There was 2 motions. 50% were for 15-year-olds. 3 of those motions, but all 3 were for attempted murder and or murder. 25% were for 1 person who was 14 years of age, and that was for murder. 83% of the total filings were for the use of a firearm and or a deadly weapon. And those numbers break down to 50% of the cases were granted that we had filed, 2 are still currently pending, and 1 of them was withdrawn. To give you kind of a breakdown of how or the process that Washoe County uses with regard to our decision-making process inside of the decision to file a motion, we're a little bit different in that we're a little bit slower than Washoe County. The way that it typically works is a young person is detained and there is a police report, typically a PC sheet that is filed, and there's a detention hearing. We're provided that probable cause statement through juvenile services the day of, typically the morning prior to the detention hearing, and that really is the first time which the district attorney's office gets sort of a review of these are the allegations or the alleged behaviors from these juveniles, and we get to make a preliminary determination based on the facts of that probable cause if we are going to consider, and I say at this point, we're considering staffing internally whether we should certify. We don't at the detention or probable cause hearing typically make statements to the tune of we are moving to certify a young person. We usually wait a little bit longer until we have the full police reports, body cam, other evidence associated with the offense. And that really is kind of on that slide we saw earlier with WDCR, which is a local rule that gives us 30 days within our second judicial district court local rules. And we use that as to our advantage, and also to the advantage of the defense counsel, and they get time to provide us with mitigation within that time of us filing. But at that time, the detention PC hearing, as you had seen from our stats, we're looking at violence, gangs, guns, substantial bodily harm. I know that we didn't have a sex assault, but we have a history previously of sex assault, attempted murder. Those are the types of cases, crimes of violence, and typically crimes of violence that resolve or result in substantial bodily harm and or murder, which is obviously a small portion of the cases that we see, thus the small numbers of cases we certify. But at that time, we make a preliminary determination. We reach out to our team and schedule a meeting among the juvenile team, the currently two deputy district attorneys and me. We'll then set up a meeting to say, hey, let's talk about this case with more information than just the probable cause. Because a youth is typically detained at that hearing, we still must file a petition within 4 days. We do that petition. We have a great working relationship, in my opinion, with the defense counsel and the public defender's office. We try typically to let them know as early as we possibly can that, hey, we are staffing this young person for certification. Please gather mitigation for us, things that we're not privy to, things their parents know, their school knows that we would like to see that could swing maybe this the other way. So they're made aware of that. If they're not made aware prior, I believe they typically are, we then come to an entry of plea on the petition. Our courts, out of practice, have not allowed a plea when the state says we are moving forward with staffing for certification, which isn't saying we are, we're just considering it. And pursuant to that local rule, we have the 30 days. The court allows us a continuance, a week or 2 weeks, at which time we will then meet, my team, with the information that either the public defenders provided us, all of the discovery that we currently have, body cam, police reports, victim statements, and then we discuss, is this a person that we should remove from the juvenile system, or at least attempt to, because it's not our decision, and send it to potentially the adult arena. We follow very closely what is already in statute and case law, which is the prosecutive merit and then the matrix that we saw that Michael had showed, seriousness of the offense, the youth's history, the seriousness of their history, and then the subjective factors of this youth. And we really go heavy on prosecutive merit up front, because if there is no prosecutive merit, there is no reason to go past that. We even go a little bit farther than prosecutive merit in the sense that if we're going to take a young person and attempt to move them to the adult arena, it would, in theory, translate to a potential jury trial in front of a jury of their peers. If prosecutive merit, which is likened to PC or preliminary hearings type standard, that's not necessarily what is required at trial. And so we will look to what do we have? If it gets certified up and it were to go to trial, does it have a likelihood of conviction? Are we convinced essentially that this kid has done what we're thinking they have done? And once we pass that, we then go into, again, the case law, the serious nature of the offense. We talk about all the evidence, the victim input. Then we talk about their history, their lack thereof sometimes. We talk about their age. We talk about their school. We talk about all these subject, mental health, evaluations, treatment. Then we look at, intertwined all this with whatever information juvenile services and the public defenders or their lawyer had given us by way of mitigation, family, school, church, sports, their plans. We take all that together, and if we at the DA's office inside our juvenile division believe that this is a case that needs a motion filed to let the court decide, even then we still don't yet file that motion. We have one more layer, and we go to our assistant district attorney, who is Zach Young. He's the head of the criminal division, and he looks at it through the very similar lens of prosecutive merit and then the case law, but looks at it through a lens of he is the trial lawyer. He's above all the trial lawyers. What evidence do we think we have? What evidence do you think we should have? And then we come together and say, is this a case that A, is provable, prosecutive merit, but not only that, but even at a jury trial? And then we look through community safety, public safety. Does juvenile have what we believe the community is willing to accept based on these behaviors in the juvenile arena, or does this risk necessitate moving to the adult arena? We currently have 33% of the people we have certified in the last 2 years, one of which was given probation, the other was currently entered into a mental health program. So 33% of those have entered into either A, back into the community for services, or into a mental health program. I will concede we don't have as robust of services with regard to kids who are certified as far as diversionary mental health programs as an adult. That is a barrier for us. Their age can be a barrier. I think Bridget Duffy will get into the needs of blended sentencing, other programmings that are available, but I would echo the statements of Chief Deputy Public Defender Cook in that services are a barrier for us in Washoe County. We oftentimes look at a juvenile and what the services are available, but we don't have gang interventions. We don't have high-level inpatient programming for some of these youth. And we also look at, if they're near 18 years old, what is the juvenile arena by way of probationary terms, conditions, state commitment look like versus the potential for adult supervision? I mean, frankly, community safety oftentimes for us, as you can see, most of these cases are going to be murders, attempted murders, gang-related firearms. Oftentimes we're trying to consider, how do we keep firearms out of these kids' hands? How do you keep the community safe? And we don't have a mechanism in the juvenile arena within a juvenile adjudication that can keep long-term a person without owning a firearm or possessing a firearm. That is a community safety risk in the state's eyes. With that, it is clear from our presentation, I think Clark County's as well, nonviolent crimes aren't being certified. You see the statute that does say someone who's 14 years old, they may be certified if it's a felony or higher, but I have 10 years worth of stats in front of me and not one single person has been certified for a property crime or anything less than a crime of violence. And all of them are battery, substantial bodily harm, robbery, deadly weapon, elder person. There's always firearms, always substantial bodily harm, attempted murder or murder in the last 10 years, or sex assault. And so the fear of the state having this great discretion to certify people who might be committing burglaries or high-level theft rings, that's not what's happening, at least in Washoe County, and not what I've heard from Clark County. I will also agree that it is currently discretionary, and the presumption is that the juvenile stays, and the court must be satisfied that has been overcome prior to a juvenile being moved into the adult arena. Thank you.
Good morning, Chair Scheibel and members of the interim committee. I am Bridget Duffy, BRIGID, DUFFY, Assistant District Attorney in Clark County in the Juvenile Division. The slides you're looking at now, I have these little asterisks. This is my exact slide from my 2023 judiciary presentation, except it's different coloring. PD Cook was absolutely correct. She would have my 100% total agreement that we need improved services in our school and community. We lack providers for therapeutic services as well as mentoring services. Most recently, Clark County also lost its only inpatient mental health treatment facility for our children. So we, like Washoe, now have 0 options for inpatient drug treatment unless that's changed in the last 2 weeks. So we do not have a system that is built to handle children that have committed these high-level violent offenses or gang members who are repeating offenses. We do not have flat time, as it's called, so we do not have determinate sentencing. You don't get, 5 to 10, 2 to 8. It's programmatic. So our facilities are program-based, so even our lockdown facility for juveniles, in order to be released from that facility, they complete a program. When they complete the program, they can get out. That program is approximately 6 months in length. That's the average time it takes. So we do not have the infrastructure to handle the more violent offenders, nor the services that exist to help them. Part of that also is that risk-reward part of the juvenile thought process. When you get, if you already know the program is 6 months, what's the risk versus the reward for the offenses that they're committing. And so that's why I have been asking for many, many sessions, along with my friends from the ACLU, to get a blended sentence model. A blended sentence model would require statutory change and create 2 categories of youthful offenders, those ages 13 to 17 and those ages 18 to 25. Next. If the adult's sentence would expire by age 25, we create a presumption of best interest of the community and the offender to be housed in a youthful offender program. It would require our Nevada Department of Corrections to maintain a youthful offender program in a facility, and that program again designated for 18 to 25-year-olds. That program would then be assist in helping youthful offenders with age-appropriate services so that when they are released, they can be actually hope to be rehabilitated because they've been in a program that helps them with certain programs in place. There would be exceptions. Of course, the youth is not following the program. They're convicted of a new crime while in the program, or they need some sort of medical treatment or specialized treatment that's not available in the program. And this didn't just come off the top of my head. This is based on statutes out of other states, and specifically one I looked at was out of Florida. I have spoken and started the conversation with legislators, hoping that somebody would be interested in taking this step forward to create a program that would be age appropriate and help offenders that are young in age. I mean, the bright line of 18 doesn't flip a switch from youth to adult. So this would even give 18-year-olds a chance, and if they were going to be released before 25, to get the programs in place that they would need and not be in a general population. I started that conversation with NDOC as well, got the numbers of what we would be looking at to create this program. I'm willing to do the legwork it takes, but it is going to involve commitment and funding so that we can do the right thing that balances both community safety and thoughtfulness of what it would take to rehabilitate a young person who has committed a violent offense and allow them to reintegrate into our society and get on a right path. I believe my next slide is questions. So again, thank you for accommodating me, and I apologize for not being there in person.
We appreciate you being here by Zoom, and we're happy to have you. And if that concludes all of our presentations, we'll move on to questions. We'll start here in Las Vegas. Any questions from our members here? All right, not seeing any. I think we have some up in Carson City, so we will go to Assemblymember Hanson.
Thank you, Madam Chair. And thank you to the public defenders, to the DAs. You do such incredibly difficult work, and balancing those scales between the two. Really appreciate the work you all do, and our hearts are heavy with some of the subjects that we have to deal with our beloved youth who really do suffer. A lot of times not because of their own fault, but because the circumstances they've come into the world with. So I wanted to start with Ms. Cook had mentioned that in Washoe County, we don't have a diversion or a specialty court for any gang-related sort of things with youth. Do we not have that in Clark County as well? And am I remembering this right, that was spoken on the record?
Michael Watson for the record. We don't have a specific specialty court for gang-involved youth, but there are gang intervention programs that are offered as part of the services that can be ordered by the court.
Okay, thank you for that. And from that then, I don't know if you'll have these numbers ready now, but of the certifications that you've mentioned for Washoe County and for Clark, do we know how many of those are in the gang-related sort of category?
Michael Watson for the.
Go ahead, Michael.
Clark County does not have those numbers specifically. Not every case is charged with a gang enhancement, so it's difficult to say which cases are gang involved. It is part of the full investigation, though, when we are researching the cases prior to any argument. We do determine gang involvement from the prior records that we have. I don't have any specific numbers, and I don't know if that's something I would be able to get by looking at the cases individually, because it's not something that would be in our Odyssey records necessarily.
Benjamin Newman for Washoe County. I don't have like the actual statistical number in front of me, but as I'm looking through these 6 kids that we had certified or filed motion in the last 2 years, 2 of them have, and we have a a gang identification within our services, and I don't know if they've truly been identified gang, but there were gang-related instances with at least 2 of them, and I think potentially a third, one of which was a murder, but I'm not sure on that. So 2 of them have at least the initial belief that this is gang and or gang-related. So in that, it is 33% of the 6 people that we had filed motion certify in those previous 2 years. And I would renew Chief Cook's request for that our Washoe County juvenile population there is a significant gang populations, and the regional gang unit and juvenile services gang unit do a good job of trying to intervene, but it truly is money and resources to extricate these kids or provide those services, and it would be a much needed, very wanted program if we're available to Washoe County. I think all would be excited and wanting something like that.
Thank you for making that point, because that having served on judiciary now since 2019, having discussions with law enforcement, with public defenders, this presence of gang activity, particularly entrapping our youth, seems to be a trajectory to continued law-breaking and danger for the community and for themselves. So I guess as a layperson, I'm trying to understand. I know that you're doing the best that you guys can within the confines that you have, but it does seem very obvious from what Ms. Cook said and what you're saying, that we need to have more specialty focus and ability to intervene in helping these youth navigate getting out of these gangs, so therefore we can hopefully mitigate things in the future. So I'm here for it, and what support I can lend, I'm willing to. Thank you.
Ben Newman from Washoe County again. Along with that gang point, I just remiss not to bring it up, but Juvenile Services and the gang unit put on a presentation recently, and I just would like to, anecdotally, the age of which juveniles are being involved in gangs a lot younger than you think. And the regional gang unit sort of indicated there is kind of a cutoff if you miss sort of the off-ramp from the gang life, 15, 16, 17, sometimes it's too late. And so these interventions need to occur at an earlier age than full-blown gang involvement. And obviously, we don't have those resources yet, but just wanted to highlight that point. They're younger than you think.
Thank you, Chair.
All right, any other questions? Not seeing any other questions. Thank you so much for your presentation and for answering our questions. I think that brings us to the end of what was originally agenda item number 6. So now we will go back to agenda item number 3 for our presentation from the Department of Child and Family Services, Department of Human Services. And just by way of update for everybody, because I know that you all are trying to plan your days as well. We'll get through at least this presentation before we break for lunch, and possibly another one depending on what our timeline is looking like at the end of this one. So please go ahead when you're ready.
Good morning, Madam Chair, and to members of the committee. My name is Kimberly Abbott, and I serve as the Administrator of the Division of Child and Family Services. And along with me today, I have Deputy Sharon Anderson, who oversees our Youth Parole Bureau and Juvenile Justice Services. We're grateful for the opportunity to be here with you this morning and talk a little bit about our work in this area. We are going to try to cover several things with our presentation this morning. We're going to talk about the statutory and federal governance. We're going to give you an overview of juvenile justice services and the trends that we're seeing. We're also going to talk about our facilities and our Youth Parole Bureau. After the Youth Parole Bureau, we're also going to touch on the potential for housing youthful offenders. Finally, we'll get to legislative updates from the 2025 session, as well as specifically the competency restoration that resulted from those legislative changes. So just our vision and our mission. We want every young person that's served by DCFS and our juvenile justice services to become a valued and productive member in the community and have a fulfilling life. And we want to enhance community safety, promote positive change, positive life outcomes, engaging families and communities in services that support positive youth development. And with that, I'm going to turn it over to Deputy Anderson, who's going to get into the meat of today's presentation.
Good morning, Chair and members of the committee. My name is Sharon Anderson, and I serve as the Deputy Administrator of the Division of Child and Family Services over Juvenile Justice Services. And it's my pleasure to share our programs with you today. So, all right, at the state level, DCFS is legally responsible for operating Nevada's juvenile correctional facilities and providing parole and aftercare services. These responsibilities include safety, programming, education, mental and behavioral health services, and reentry support. NRS 62 outlines the juvenile justice process, including adjudication, diversion, detention, and court authority. NRS 63 establishes the Division of Child and Family Services Authority to operate state juvenile facilities and sets expectations for care, safety, and programming. And then it's NRS 63, not 62H. Apologies for that. It defines the responsibilities of the Youth Parole Bureau, including supervision, conditions of parole, and discharge requirements. So together, these laws define how we operate facilities, provide services, and support youth returning to their communities. So the Juvenile Justice and Delinquency Prevention Act establishes baseline requirements that states must follow to remain compliant and maintain federal funding. Beyond the 4 core requirements, it emphasizes trauma-informed approaches, family engagement, evidence-based practices, improved facility conditions, and limits on restraints for pregnant and laboring youth. So our Juvenile Justice Programs Office provides statewide oversight of Nevada's juvenile justice system. Key responsibilities include managing federal grants, ensuring compliance with the Prison Rape Elimination Act standards, that's also known as PREA standards, developing policies, and supporting the Juvenile Justice Oversight Commission. They also collect statewide data to guide decisions and identify opportunities for improvement. Juvenile Justice Services helps youth get back on track while keeping communities safe through secure care, education, treatment, and reentry support. This work matters because youth can change with structure, treatment, and support. Many youth come to us with trauma or unmet behavioral health needs, and our system is designed to address those issues, not just impose consequences. So this process begins in delinquency court. If the court orders state-level services, DCFS provides secure care at our facilities, followed by supervision from the Youth Parole Bureau. That's right. So a youth is successfully discharged when they complete court-ordered conditions and have reintegrated back into their community. So this slide that you're seeing now is that famous juvenile justice funnel. So this slide, this shows you where the community prevention and diversion programs significantly reduce the number of youth who reach state custody, and that's seen by the narrowing of the funnel. So the next few slides are just going to show you some of the data that our programs office has received and recorded in some of our published reports. So as you can see, referrals have decreased 32% from federal fiscal year 2024 to federal fiscal year 2025. And diversion has increased steadily since 2022, rising from 30% to nearly 75% in 2025. So Nevada averages about 2,300 probation placements annually. And this represents roughly 17% of referrals, rising from 16% in 2022 to 21% in 2025. So in 2025, we had a total of 213 youth placed in county youth camps. 71% were placed at Spring Mountain Youth Camp, 21% at China Spring, and 8% at Aurora Pines. And then this slide shows youth committed to DCFS from 2022 to 2025. When youth are committed to DCFS, many have experienced instability, trauma, or violence. Our admissions team reviews each case to determine the safest, most appropriate placement based on history, risks, and needs. Most youth are appropriate for placement in one of our state facilities. These are youth who have not been successful with county level interventions, their behavior has escalated, or the seriousness of their offense leads the judge to bypass county interventions altogether. And most youth are placed in one of our state facilities, either the Caliente Youth Center, which is a staff secure facility, and this means that it is not a locked facility. The Nevada Youth Training Center also is a staff secured facility and not locked, or the Summit View Youth Center, which is our highest level security facility, and it is a locked facility. So some of these youth committed to our care, though, are not appropriate for one of our juvenile justice facilities. These are youth with severe behavioral and mental health needs. A common example might be a youth who has attempted suicide multiple times in a short period of time, has multiple co-occurring diagnoses, or has significant intellectual or developmental disability. These youth may be diverted to in-state or out-of-state programs. We also face challenges with youth who are involved in both the child welfare and juvenile justice services systems, particularly those who don't have placement after they've earned parole. Many of the youth placed in our state facilities have significant mental health needs. Some struggle with severe depression, trauma-related symptoms, or emotional dysregulation. Our staff work incredibly hard to support these youth and deliver programming that meets their unique needs and responsivity. In every case, with every youth, the work is about safety, stability, and giving them a real chance to heal and succeed. I also want to clarify 3 key operational metrics that directly impact our ability to safely serve youth in our state juvenile facilities. I'm going to be talking about budgeted capacity, staffing capacity, as well as our census. So budgeted capacity is the number of beds we're funded and authorized to operate, and this number doesn't change day to day. But staffing capacity tells us how many youth we can safely supervise with the staff we actually have on shift. So this number can fluctuate daily based on vacancies, leave callouts, and our required staff to youth ratios. So in practice, staffing capacity is the true operational limit, because even if we have the space and budget for more youth, we cannot exceed what we can safely manage with available staff. And then finally, census. That is our real-time daily head count. It's the number of youth physically assigned to the facility, and the census is updated daily and is the most immediate indicator of facility demands. Next, I'll talk about admission wait times. Those are affected by post-adjudication required assessments and placement decisions. Also, staffing capacity at the receiving facility, transportation schedules, medical clearance requirements, and availability in specialized mental health programs. Youth with high-level mental health needs may wait longer due to program criteria, limited beds, or required clinical reviews. Cases with extended wait times are placed on calendar to ensure transparency and to provide updates for all parties. These steps ensure youth are placed safely, appropriately, and with the right supports. Once committed youth arrive at one of our facilities, it is not our job to punish them. We provide a comprehensive array of services to address their specific identified needs. Remember, Nevada does not have determinate sentencing for juveniles. DCFS has programming that lasts on average between 6 to 9 months. We don't want youth in our facilities longer because we know research shows keeping youth longer does not improve outcomes and can negatively affect their mental health. Each facility has an on-site school that allows youth to earn credits towards their high school diploma, or they can earn a high school equivalent certificate. We have some career and technical education opportunities in culinary, graphic arts, and textiles, and each facility offers mental health services. So this slide shows the variety of mental health and substance use services at each of the 3 facilities. Our mental health teams and our facilities work hard to address the mental health needs of the youth in our care. We continue to see youth with high level acuity needs, including youth with self-harm thoughts and behaviors. Our facility staff are an incredible group. They care about these youth in their care. They work hard to ensure youth remain connected to their families and support systems while they're in our facilities. They are deeply committed to youth safety and well-being, often intervening in medical or mental health crises and covering extensive overtime to maintain required supervision ratios. When youth are committed to DCFS pursuant to NRS 62E520 for correctional care or other facility, our Youth Parole Bureau begins the intake process. Youth are assigned both a youth parole counselor and a mental health counselor, who are the first contacts the youth has with the division staff while they are in their local detention facilities. The DCFS admissions team reviews all youth documents, screenings, and assessments. They evaluate the youth's needs and make recommendations for admissions and placements. When youth complete facility programming, youth parole supervises their transition back into the community. Case plans may include a GPS ankle monitor, treatment services, skills trainings, and support with education or employment. Parole counselors focus on accountability and on helping youth develop the stability and skills needed to remain delinquent-free. Youth Parole also supervises youth who are on parole from other states through the Interstate Compact for Juveniles. So now I'm going to provide a high-level summary of the Housing Youthful Offender Study results that pertain to our state facility. The Housing Youthful Offender Study reviewed Summit View Youth Center as a possible location for youth currently in the Nevada Department of Corrections custody. The study concluded that Summit View Youth Center is not a viable option due to legal and operational requirements to fully separate Nevada Department of Correction youth from the Division of Child and Family Services committed youth. They identified security gaps for higher risk Nevada Department of Corrections youth. They indicated the need for major staffing increases and costly facility upgrades, which would require new construction with costs exceeding over $30 million. So the study noted using Summit View Youth Center for the Nevada Department of Correction youthful offenders would strain operations, reduce services for current youth, and introduce safety risks. It was further recommended that maintaining the Summit View Youth Center for DCFS needs is the most responsible path forward. All right, so this slide provides an update on the status of bills that were passed during the last session. We have Assembly Bill 89, which requires all juvenile facilities to adopt strict policies governing unclosed searches. So policies, procedures, and trainings have been updated, implemented, and trainings are ongoing statewide. Assembly Bill 67 addresses competency restoration, and Administrator Abbott will provide information on this bill and its status.
Kimberly Abbott, again for the record, and I realized I didn't spell it last time, ABBOTT for the record. So AB 467 that came out of the last session amended NRS 433B, and it requires now that when the court determines a youth needs competency restoration and that restoration needs to happen in a residential setting, DCFS must immediately make arrangements for that youth. And so just after session, we had to figure out a plan quickly for these youth. We have Desert Willow Treatment Center, which is our psychiatric hospital here in Las Vegas. So one of the psychiatric units, particularly the unit that used to serve acute youth in Las Vegas, was converted to accommodate this new competency restoration program that we had to establish. Unfortunately, that means as the safety net hospital, we aren't able to accommodate acute youth, and acute youth are now being diverted to private hospitals. We do have a contract with several private providers to help take youth who are uninsured or underinsured. The restoration process it includes some groups that are held with a clinician twice per week. They cover 10 topics. They do a third session, which they focus on rational decision making, or they do mock trial work. And then also monthly, they try to meet with their defense counsel to help prepare the youth to be able to assist within their defense. The current programming we have a 10-bed capacity. Our average daily census in 2025 was 6 to 7 youth. That is pretty much held true into 2026 as well. As we sit here today, we have 7 youth on the unit. In 2005, 10 youth were admitted from the opening of the program mid-year through the end of the calendar year. At that point, they were all male, and they were ages 13 to 17. So far in 2026, we've had 5 youth admitted, and I need to make an update to the slide. It's actually 3 males and 2 females. We had a female admit since I prepared this information. I don't have data on current data for 2026, but as of the end of the 2025 calendar year, the average stay in the program was 122 days. So far total, and I'm just going to add a couple statistics I was able to pull as far as results since we submitted the slides. 15 youth in total have been admitted to this program since it began. 4 have been successfully restored to competency, returned to detention, able to carry on with their cases. We've had 3 that were not restored. 1 was deemed to be not restorable or unable to be restored to competency. That youth ended up being further ordered pursuant to the process that was discussed earlier when the court reviewed the 13 factors. They ordered that youth to be committed to the residential treatment site of Desert Willow for a few months. One of the other youth was released back into actually 2 of the other youth were released back into the community after they were continued to be deemed incompetent. And then we have 7 that are still in the program and working through the process. We pulled some of the statistical data to give us a profile of the types of youth that are coming to the inpatient competency restoration unit. As Ms. Cook was talking earlier, I was thinking our data on this slide basically substantiates all of the statements she made about the nature of the youth who are in general in the delinquency system, because most of that played out here in these statistics. Biological and family background, 100% of the youth that have been in this unit in 2025 had some disruptions in their biological families. 70% there was a history of serious mental illness in the home. 60% there was substance abuse by parents in the home. Also really important to note, 60% have a documented intellectual or developmental disability or delay. Interestingly, 40% had a history of seizures as well. Half of the youth that we had in the first half of the year that this program was open had their own substance abuse issues. And then you can see there the variety of psychiatric diagnoses that the youth had. Also, I think really telling, 100% had experienced trauma in their histories. They had at least 2 adverse childhood experiences by the time they came to us in this program. That is the conclusion of our presentation, and we will gladly take any questions you may have.
All right, questions from members here in Las Vegas? Okay, I don't see any questions here in Las Vegas. We'll go to our remote and Carson City members. I'm not seeing any questions there either. I think you've answered all of my questions as well. So we very much appreciate you being here. Thank you for taking the time to join us this afternoon. And we will move on now to our next presentation. So I'm going to go ahead and open up agenda item number 4 and invite our representatives from the Juvenile Justice Oversight Commission to the front.
Good morning, Chair Scheibel and members of the committee. For the record, my name is Javier Carlson, that's Karlson, and I serve as the chair for the Juvenile Justice Oversight Commission. I appreciate this opportunity to provide an update on the commission's work. The commission is comprised of 25 members appointed by the governor, with membership requirements established under Nevada Revised Statute and the Federal Juvenile Justice and Delinquency Prevention Act. This presentation is intended to provide an overview of the statutory role of the Juvenile Justice Commission, update the committee on the implementation of Assembly Bill 384, report on the progress under the 2024-2029 Strategic Plan, outline the Commission's role in developing and monitoring the three-year plan, and to inform this committee on the potential statutory recommendations that may result in a future bill draft request. Under NRS 62B 600 through 62B 645, the Commission serves as the state's central oversight body for the Nevada juvenile justice system. The Commission is responsible for ensuring accountability, compliance, and continuous system improvement through data-driven decisions, collaboration, and policy leadership. In 2025, AB 384 expanded the Commission's responsibilities to include a more structured and proactive role in assessing service delivery, identifying system gaps, and incorporating stakeholder input. The Commission also serves as the Nevada State Advisory Group under federal law, linking state-level oversight with federal juvenile justice requirements. Additionally, the Commission is responsible for developing and monitoring a 5-year strategic plan, which establishes measurable goals, tracks progress, and ensures sustained system improvement efforts. The Commission is a federally mandated body under the Juvenile Justice and Delinquency Prevention Act and is directly tied to Nevada's eligibility for Title II formula grant funding. Compliance with the 4 federal core requirements is mandatory. These include the deinstitutionalization of status offenders, sight and sound separation, jail removal, and addressing racial and ethnic disparities. The 3-year plan, which I will address shortly, is another key federal requirement tied to these protections. Assembly Bill 384 expands the statutory role of the Commission beyond oversight and compliance to include a proactive, structured approach to system assessment and improvement. Under 384, the Commission is required to conduct structured stakeholder engagement, examine juvenile justice services statewide, review wraparound services for involved system youth, identify service gaps and systematic barriers, develop findings and recommendations, and submit an annual report to the legislature by March 1st of every year. Since the passage of AB 384, the Commission has taken several foundational steps. We approved the 2026 scope of work, which is focused on re-entry and transitional support. We adopted bylaw revisions to align governance with changes in statutory requirements. We integrated AB 384 responsibilities into our committee structures and initiated the development of a task force. We've identified key stakeholders for engagement, and we've established implementation timelines to meet reporting requirements. The AB3 task force is going to focus on the items listed, which include reentry coordination gaps, rural services access, workforce capability challenges, cross-system collaboration, and wraparound services. The Commission anticipates launching the AB 384 task force in June of 2026 Following its launch, the task force will begin data analysis with outreach to providers, with surveys potentially used to support stakeholder input. By late 2026, the task force is expected to present its findings and submit a draft report to the Planning and Development Committee for review and refinement. The final report will then be presented to the Commission in February of 2027 for approval before its submission to the legislator by March 1st of 2027. The strategic plan, five-year plan, is designed to support statewide and data-driven systems grounded in evidence-based practices. Key accomplishments to date include development of a statewide inventory of evidence-based programs in partnership with the National Center for Juvenile Justice, execution of statewide data sharing agreements with all county juvenile probation departments, and significant progress in implementation of family engagement handbooks across the jurisdictions. Additionally, the Strategic Planning Committee recently conducted a comprehensive review of the plan to ensure alignment with statutory authority. As a result, goals outside the Commission's authority were removed and priorities were refined to better reflect the Commission's core responsibilities. This type of review is essential to maintain focus, compliance, and effectiveness. Three-year plan required under federal law serves as Nevada's roadmap for juvenile justice system improvement. It outlines how the state will maintain compliance with federal requirements, identify system needs through data and stakeholder input, establish statewide priorities, guide the use of Title II funding, and support evidence-based programming. Nevada is currently in year 2 of our three-year plan and will soon begin the development of the next cycle. The Commission will be in support of this process through data analysis, stakeholder engagement, and identification of service gaps, ultimately establishing funding priorities aligned with both federal requirements and state needs. Title II funding is flexible, but we must align with federal priorities and identify system needs. Eligibility uses include compliance monitoring and system improvement, prevention and early intervention, behavioral health treatment services, alternatives to detention, reentry and aftercare, system coordination, capacity building, and evidence-based programming, and youth and family engagement. As Nevada's state advisory group, the Commission plays a central role in setting funding priorities, reviewing data, and recommending program investments. In recent weeks, the Commission's standing committees have conducted a targeted review of statutes governing the Commission. This review identified areas where clarification, modernization, or alignment may be needed. If I may, I will provide an example. Because the Commission serves as the Nevada State Advisory Group under the Juvenile Justice and Prevention Delinquency Act, its membership must specifically satisfy federal requirements as well as the NRS. Included in the federal requirements are a majority of non-governmental members, inclusion of youth members, and a representation of required stakeholders. Aligning state statute with these federal requirements would help ensure the Commission is structured in a way that is fully consistent with both state and federal law, reducing the risk of meeting one set of standards while falling short of the other. It would also provide clearer statutory direction for appointments and membership maintenance, in addition replacing the current fixed 25-member structure with a federal range of 15 to 33 members that would give the Commission greater flexibility to maintain compliance, respond to vacancies, and ensure all required categories of the representation are filled. Proposed statutory changes will be presented to the Commission at its May 11th meeting. At this time, no formal action has been taken and no bill draft request has been submitted. If the commission approves the proposed changes, we will be seeking legislative support to advance these recommendations in the next sessions. In closing, the commission is committed to transparency, data-informed decision-making, collaborative system improvement, supporting Nevada's youth and family, and partnering with this body. We value the opportunity to work with this committee as we continue to strengthen Nevada's juvenile justice system. I am now available for any questions, and I apologize, I did not spell my last name either, but it's Karlson.
All right, thank you so much. Are there questions from our members here? We'll start with Assemblymember Cole.
Thank you, Chair. First of all, I just wanted to say thank you very much for the presentation on AB 384. This bill is, or law now, is near and dear to my heart. So I wanted to say thank you to my Chair Miller for bringing this bill through the committee and helping me to make the changes so that it actually became law. And then I just wanted to say thank you to the Oversight Committee. I think that you are doing an amazing job. And we had this conversation a few weeks ago when we talked about the implementation, but I just want to commend you for doing such a thorough and quick job of implementing it and really getting to work to make it what I hoped it would be. So thank you.
Other questions here in Las Vegas? All right, we will go to Carson City and remote. I'm not seeing any questions, so thank you so much for your presentation and for being with us here today. That brings us to the conclusion of this agenda item. At this time, we are going to take our break for lunch. We will come back at 1 o'clock, and I will see you then. Thanks. right, I will call this meeting back to order. Appreciate everybody's patience with us. At this time, we will go ahead and move to the next item on our agenda, which is item number 5. These will be presentations from local juvenile justice services on housing for juvenile offenders. And we will welcome you up to the front whenever you're ready.
Good afternoon, Chair Scheibel and members of the committee. My name is Elizabeth Flores, Elizabeth and I am the Director of Washoe County Juvenile Services in Reno, Nevada. And thank you for having me here. That's Clark County's presentation, I believe. Oh, there we go. Sorry, I'm looking at the wrong screen. Okay. So my hope during this presentation is to answer questions relating to housing models, female youth in custody, and key challenges and promising practices. I'll also provide a brief background of our department. Thank you very much. Okay. I'm here today representing the Jan Evans Juvenile Justice Center. Jan Evans, as many of you may know, was an assemblywoman who was an advocate for children in both the dependency and delinquency system. Our mission is to promote community safety and positive youth development by providing a continuum of interventions to justice-involved youth and their families. Our department is governed by Title V, Chapter 62, and we are administered by the 2nd Judicial District Court. We have an administration, a juvenile detention center called Wittenberg Hall, probation services, community services, traffic court, and clinical services. Since we are talking about housing models, I felt it was important to highlight that detention centers provide short-term secure custody and are distinct in both design and function from longer-term camps such as China Spring Youth Camp and Spring Mountain Youth Camp, as well as state placement settings. In the state, we have 17 counties, 11 judicial districts, but only 7 have detention centers. So the remaining 4 judicial districts, who are the 3rd, 5th, 7th, and 11th, must contract with other districts when they are seeking a detention placement. Wittenberg Hall opened in 2004 in the Jan Evans Juvenile Justice Center. The original building was constructed in 1961. We have 108 beds. Our educational services are provided by the Washoe County School District. We have food and nutrition services, mental health services, a medical clinic, and community partners also provide activities and education for the youth in our care. With that, it's important to provide context to the volume of referrals that we receive within our organization. And I'll shift to overall referrals and admission trends over time. I did a 10-year snapshot, 3 different points in time going back to 2016. And you can see in 2025, we had a significant reduction in the number of referrals. So a total of 2,643 referrals, which are comprised by both arrests and citations. And if you look at the blue line that says admissions, that's the number of youth who are actually booked into our Wittenberg halls. So less than 50% of our total referrals actually come through our detention doors. To also provide more context, in 2025, females made up less than 30% of all of our referrals and less than 30% of all admissions or arrests. And for context, females make up about 50% of our school-age population in Washoe County. For detention trends, you'll see on the left our average daily population, again, a snapshot over 3 years in a 10-year span of time. In 2025, our average daily population was 26, and 80% of the youth on a on any given day are males, and the remaining 20% are females, actually less than that. And if you look at our average length of stay, we have two metrics that we always calculate. The dark bold line on the bottom is when we start counting from the time they come into our facility to the time they leave the facility. So last year, the average length of stay was 14 days, which is also a decline from previous years. But the other metric we track is the average length of stay for youth who stay over 3 days, because by that time they've had a detention hearing and have been heard before a juvenile court judge. And that number is always at least a month long, because those are youth who are typically waiting for a placement. And last year it was higher than in the previous 10 years, was 37 days. Males stay typically twice as long as females. The average length of stay for females is 8 days, and for males it's 16. This funnel has been seen in many different variations over the course of the last 10 to 15 years. It was actually created by my predecessor, Frank Cervantes, and it's really just an excellent demonstration of how it is that youth move through our system, and that's why it's very popular to show the flow of cases. What I'll add to this is we've added a behavioral health placement on the left side of the funnel. That's a new component. Even though most agencies across the state have utilized residential treatment programs, I felt it was time to put it on the chart because we have a significant number of youth who are placed in residential treatment centers. In Washoe County, we are very committed to diversion, and so we make every effort without compromising community safety to have youth exit the funnel at the earliest point possible. Our supervision outcomes you can see here. In 2025, 75% of all of our cases were diverted from court or closed with informal sanctions. We also track recidivism. Our reoffense rate for felony and gross misdemeanor offenses in the subsequent 24 months for youth who were placed on probation, you can see for those placed on probation in 2023, after 2 years, 78% had no reoffenses with felony and gross misdemeanors. 16% had 1 reoffense, 4% had 2, and 2% had 3 reoffenses. And while recidivism and diversion are really important numbers to track, it doesn't tell the whole story. Our hope is that through our case management practices, that youth can be successful upon their separation from our involvement with our agency. The next chart shows our residential treatment center trends, again showing in 3 points in time over the last 10 years. And the blue bars show in-state residential placements, and the purple are out-of-state, and I'll call them RTCs just for brevity. But you can see that it went from 71 in 2016, 52 in 2019, and 47 in 2025. There's been a decline in total residential treatment placements. Our out-of-home placements have declined for both males and females, and total placements are higher among males, especially out-of-state. Females have a higher placement rate when adjusted for referral volume, and the remaining out-of-state placements are predominantly male. A recent phenomena we're seeing in 2024 and in 2025 is that the number of RTC placements that we've had have exceeded the state and county commitments combined. So a lot more residential placement treatments relative to state and county commitments. In 2025, about 46% of all of our RTC placements were females. And I had stated earlier that they make up about 30% of our overall referrals, and they make up about 23% of the youth we have on supervision. So 46% demonstrates that there's an overrepresentation of females in our RTC placements. At this time, I also wanted to note our experience with commercially sexually exploited children, or CSEC youth. In looking at the past 5 years, the average number of suspected CSEC cases that we've received is about 20 per year, and about 50% of those have been confirmed victims of human trafficking. Females comprise over 95% of those referrals that we receive, and about 25% of the confirmed victims are placed in residential treatment centers. All youth where there is a suspicion are referred to our Human Services Agency for abuse, and we also coordinate services with with the HEAT team, or the Human Exploitation and Trafficking team, which is a law enforcement entity on all of these cases. All youth are referred to trauma-informed treatment, whether in the community or at a residential treatment center. For state and county commitment trends, you can see the blue line are state commitments and the purple are county, so China Spring Youth Camp commitments. For both state and county, the commitments have declined significantly over time. Males comprise the majority of the commitments. The declines in the numbers are primarily driven by males in our system. Last year, we committed 3 females to the state and 3 females to China Spring Youth Camp. So again, females, their placements are, the majority of them are in residential treatment centers, not necessarily in commitments. I did want to add at this time, I'm going to go off script a little bit, related to the gang conversation that happened in earlier presentations. I was not prepared to give that today, but I did want to just share some statistics that we have in Washoe County related to gangs. We have been tracking for the last 20 years the total number of serious offenses, and for purposes of the study that we do, we define serious offenses as all felony and gross misdemeanor, violent, sexual offense, and firearm charges. So all violent offenses, sex offense, and firearm charges. And there has been a significant decline over the last 20 years in the volume of referrals that fall into that serious offense criteria. Pretty consistently, gang members make up about 10% of the volume of total serious offenses in Washoe County. We talk a lot about gang members, but overall they are a relatively small proportion of the number of serious offenses. What I do not have, but I made a note to track in the future, is to look specifically at our certification cases. I know that that was mentioned earlier, so that we can have a better understanding of how many of our certification cases are gang members. The next slide shows our felony drug offense trends. Again, overall, our referrals have declined by 17 or 18% in the last 17 years. 10 years. However, our drug-related felony possession offenses are making up a growing share of total referrals. Females are showing a faster growth rate in this category. So if you look at 2016, 8% of our referrals were females in the felony drug category. In 2019, it jumped to 29%, and in 2025, it's stabilized at 28%. So it shows that females are making up a much larger proportion of our felony drug cases. The majority of these cases are related to concentrated cannabis. The next slide shows our person offense trends by gender. Our person offenses are also making up a larger proportion of our referrals. 10 years ago, person offenses, like any violent offense, for us, the majority are battery and domestic battery, but there are other far more serious charges. It used to be 17%, and now person offenses make up 27% of our referrals. And females are also growing in this category, unfortunately, with the percentage of referrals. I'll move on to legislation. These are the bills that pass that have the most impact within our organization. I'll first speak about AB 89, which established standards for youth unclosed searches in detention. AB 167 requires a review of room restriction for youth with mental health conditions who've been in their room for over 24 hours due to corrective room restriction. And SB 241 revised probation term limits, addressed restitution and due process for probation violations. In all 3 of these categories, we were already largely in compliance and accomplishing this. But after these bills passed, we adjusted our policies and our procedures and have now trained all staff so that we are in full compliance with all of these bills. AB 467 clarifies placement responsibility for incompetent youth. I know in previous presentations that was discussed at length. There's one youth in Washoe County that was moved from our detention center, who had been in our detention center for a year and has been at Desert Willow now since last September. AB 384 is the Juvenile Justice Oversight Commission study, which was discussed earlier. And AB4 was the large crime bill, and the juvenile impact requires detention for certain repeat offenses and adds mental health evaluation and supervision options. We've had less than a handful of these cases so far in Washoe County. For our challenges, a lot of this will not be new to members of the committee. Approximately 60 to 70% of the youth in custody present with significant behavioral health needs, many requiring psychotropic medication. We have limited availability of quality residential treatment beds, both acute and long-term, and we also have few evaluators who are qualified in our community to evaluate adolescents. So that's another challenge, especially when we have youth waiting for evaluation in our detention centers. Youth in detention and on supervision present with increasingly complex medical and behavioral health needs that require interventions beyond the scope of what our probation and detention staff can provide. Also, we have workforce challenges, including turnover and vacancies among our detention and clinical staff, which impacts our ability to provide service. I also felt it was important to provide a rural juvenile justice perspective. All of the directors and chiefs and other administrators across the state, including DCFS, are part of the Nevada Association of Juvenile Justice Administrators. And this list and slide was compiled with their contributions and with their approval. Their challenges include younger, higher need youth entering detention. Their very high lengths of stay within their detention centers. They have small facilities, or they must contract for beds. They have capacity limits that prompt constant triaging. Significant staff time is spent coordinating placements as well as transporting youth. They have limited behavioral health providers, and those that do come at high cost or include travel. They have reliance on non-general funds. They have facility constraints that limit proper classification and separation because they're so small. Most of the other facilities have maybe 16 beds, where in Washoe we have 108, and Clark County has at least double that. Their system impacts are that there are extended stays for youth who are awaiting placement. They have increased reliance on detention when no alternatives exist. They have elevated safety risks from mixed populations within the detention centers, and detention is used beyond short-term stay purpose. What is working is that they have strong regional collaboration and adaptive problem-solving staff. So I hope that represented the rural experience, and we do have a rural director in the audience if questions arise later. Promising practices in Washoe County. Specific to our department, we have re-entry supports where we partner with the China Spring Youth Camp and with the Children's Cabinet to provide a program called Positive Pathways to Reentry. It actually reentry planning starts the day they enter the camp, and there's a collaborative effort that includes the youth, the family, service providers, so that when the youth transition home, there's a wealth of individuals who are waiting to support them. We also have partnered for many years with the Washoe County School District, where for all youth who are coming back into our community, whether it be from the camp or from other placements, that there is a planning meeting to ensure that the school is provided to meet all of their needs as they re-enter our community. Another Washoe-specific program is the multisystemic therapy. We're really proud of this program. It's an evidence-based in-home therapy program, and a very intensive model for youth who are at risk of being removed from their home, either to a commitment or to a treatment center. It's in its infancy. It's a couple years in the making, but it's showing great promise at this time. At the county level, we have the Washoe County Behavioral Health Center, which this body is aware of, which is under redevelopment and active construction with targeted opening in 2027. And their focus population is Washoe County youth who are in need, but also including juvenile justice youth and children who are in the child welfare system. We also have our own mobile crisis team, which they've been excellent partners to us in Washoe County. And at the state level, what we are looking forward to are the efforts of the Medicaid Reentry Project, as well as the Children's Behavioral Health Transformation, which was spurred by the Department of Justice investigation, because we recognize that will expand services for youth in our care. And that concludes my presentation, and I can take questions. Thank you. I took that 10-minute rule very seriously, so.
What was that?
I was trying to stay under my time limit, so I rushed. I apologize if it was cluttered.
No. We appreciate that, and we appreciate your presentation. Do the members here in Las Vegas have questions? All right. Anything in Carson City or online? Okay, go ahead, Senator Krasner.
Thank you, Chair. And thank you for your presentation. I appreciate that update and how you're complying with the laws that we passed in the 2025 legislative session. I was just wondering, how are we doing in Washoe County regarding automatic sealing of juvenile records for offenses that would be considered a misdemeanor? Thank you.
Thank you. Thank you. This is Liz Flores for the record. The courts actually would have to answer part of that question. I know from our department standpoint, we are in compliance with all the orders that we receive from the court to seal. We immediately seal within our case management system. If you need further detail, I would certainly be willing to investigate that and report that back to you.
Thank you very much. I appreciate that. I would love to hear an update on that. Thank you.
Certainly.
All right, any other questions from our friends afar? Not seeing any. I do have one question. And I think this was back on about slide, well, maybe 6 or 7. It was about the percentages of different cases that you're seeing now. And I want to make sure that I'm understanding correct. I think you kind of indicated that the number of person or the percentage of person offenses is increasing. And I'm not sure if you have an evaluation of whether that's, good, bad, or otherwise. But I'm wondering if it's possible that we're seeing that increased percentage because we're seeing fewer drug offenses, fewer, petty theft offenses, fewer smaller offenses, and that might actually be a positive outcome that the kids who are becoming justice involved are becoming justice involved at the point where they're committing person offenses as opposed to the less concerning behaviors that we could hopefully handle outside of the juvenile justice system. I'm wondering if you could kind of help me. Am I on the right track or am I misunderstanding the data?
Thank you for the question, and I'll attempt to answer it like this. We have seen, conversely, a reduction in the number of property offenses. So so for the petty larcenies, those fall under, for us, the property offenses are categorized like the petty larcenies, and those numbers have they ebb and flow, but the property offenses have decreased while the person offenses have increased. The reason I flagged the person offenses is because I was trying to highlight areas where we're seeing a change in female offending behavior, and that's the reason that I brought this forward.
Okay, thank you. And so it sounds like that is increasing in the female offenders, which is interesting, if nothing else. I'm not quite sure what to do with that information, but definitely I appreciate you bringing it to our attention. If there are no further questions, we will move on to our next presentation.
Thank you.
Good afternoon, Chair and members of the committee. My name is John Munoz, John-Munoz, and I serve as the Director of Clark County Juvenile Justice Services. I want to thank you for the opportunity to present an update on Clark County Juvenile Justice Services. In the interest of time, I will try to provide a high-level and high-speed overview of operations, recent trends, system challenges, and promising practices that reflect our commitment to youth, families, and community safety. Director Flores did a great job providing an overarching review of juvenile justice services in the state. We all follow the same concepts, principles, statutes. So I'll try to proceed with collectively providing an overview of what juvenile justice services in Clark County does. Our mission and vision our mission and vision anchor everything that we do. We focus on strengthening families, building positive relationships, and promoting opportunities that create safer communities. This work is rooted in evidence-based practices and is designed to balance accountability, treatment, and long-term success for youth. Juvenile Justice Services is a comprehensive continuum of services from diversion to detention to residential programming and probation. Our structure allows us to match youth with the right level of intervention, preventing deeper system involvement while ensuring community safety. Our detention center is a 192-bed facility that is secure and designed with safety, structure, and developmentally appropriate programming at the forefront. We use a validated risk and behavioral health screening tools at intake while seeking an appropriate placement and supportive services. Detention functions as a short-term, structured setting that works to identify youth needs and link youth and families to services that promote safety, stability, and reduce future system involvement. So this looks like your impromptu eye exam. This seems a little smaller than I expected. Sorry about that. Programming in detention prioritizes mental health, education, physical wellness, and meaningful development. We have expanded gender-responsive programming, which is critical as we see more complex needs among system-involved girls. The Elevate Girls Initiative and Girls Circle provide trauma-informed support designed to reduce exploitation, improve decision-making, and empower young women. Over the past 3 years, we've averaged nearly 9,500 referrals annually, just a little bit higher than Washoe. This volume reflects significant community demand for services and highlights the importance of prevention and diversion efforts, as well as strong, effective case management and community supervision for higher risk youth who remain on probation in the community. These practices are essential for supporting positive behavior change while maintaining public safety. You'll also see that roughly 4,000 youth are booked into detention each year. Not every youth is detained. Our assessment tools ensure detention is reserved for youth who pose a safety risk and require court-ordered detainment. Of the youth arrested and booked, about 1,900 annually are detained in detention. Our consistent use of the juvenile detention alternative instrument helps prevent unnecessary confinement. Our average daily population for the last 3 years is 163 youth. Our average for 2025 was 139 youth, which is almost a 15% reduction. While the length of stay saw a slight increase in 2024, it decreased again in 2025. The length of stay is influenced by various factors, including case complexity, court timelines, and availability of community and treatment resources. Excuse me 1 second. Spring Mountain Youth Camp is a critical component of our continuum, providing structure, education, and growth for our court-ordered youth in the program. Spring Mountain Youth Camp is a 100-bed facility for boys. Camp placements have remained stable, demonstrating consistent need for this type of intervention. Compared to Spring Mountain Youth Camp's average of 164 youth annually, commitments to DCFS average about 200. This reinforces the importance of maintaining both county level and state level placements to address a wide range of youth needs. Camp provides a comprehensive set of academic, vocational, therapeutic, and recreational programs. We emphasize skill building and culinary, forestry, maintenance, apprenticeships, etc. All youth participate in sports, clubs, and workforce development, and these programs directly support reentry success, employability, and positive development. Probation is one of our largest divisions, focusing on case management, accountability, family engagement, and targeted interventions. Director Flora has already discussed probation services, so we want to focus more on gender-specific programming for girls. Pivot Point offers a comprehensive trauma-informed responsive residential program designed specifically for girls ages 12 to 18, recognizing the unique needs of this population. The program operates 2 specialized homes, the Cedar House for short-term stabilization and Sage House for a long-term treatment-focused care, providing structured support in a safe, home-like environment. Youth receive individualized services grounded in an integrated care model that prioritizes safety, assessment, and holistic understanding of each young person's strengths and needs. Both homes emphasize cognitive, behavioral, social, educational, and vocational skill development, supporting youth in meeting their case plans, court expectations, and long-term goals. Pivot Point serves as an essential resource for girls who cannot safely remain at home and who benefit from a structured therapeutic setting to support stabilization, healing, and successful reintegration in the community. Group homes and behavioral health placements offer structured environments with counseling, education, support, and case management. Many youth in these settings present clinical needs that require specialized treatment and stability. We continue to work with providers to improve oversight, programming, and outcomes. Out-of-home placements. We have seen a 78.6% increase in female out-of-home placements over the last 3 years. We attribute this high increase in part to the creation of our Pivot Point residential treatment program. I think as of 2023, there have been 63 girls placed into that program. This underscores the growing complexity of needs among girls, particularly around trauma, mental health, and family instability. Placement trends. We supervise an average of 74 youth in out-of-home placements annually. Youth remain in placement an average of 169 days, which is reflective of treatment duration and case complexity. Timely access to quality placements is vital to both youth progress and timely court closure. Did I mention this is going to be a high-speed presentation? Speaking points regarding recent legislation. So Director Flores did a great job explaining what this legislation means to the state and our compliance with these expectations. Clark County, as well as is in compliance with the changes that were made. We remain committed to full compliance and welcome continued dialogue to ensure clarity and consistency. Some of our challenges. Like many agencies, staffing remains one of our greatest challenges. We currently have 58 vacancies, including 35 probation officers, which is kind of a lot. Clark County Juvenile Justice Services employs 401 total positions in the department with a total of 46 vacant positions. We have 228 juvenile probation officer positions, and we currently have 36 vacancies. We have a critical labor shortage designation for juvenile justice services in Clark County and continue to modernize recruitment and retention strategies. We're also seeing increased youth access to e-bikes and e-scooters, creating new safety and enforcement concerns. Substance abuse among youth continues to rise, but inpatient treatment options remain limited, as was mentioned earlier in the presentations. Community service requirements under NRS can unintentionally extend probation, and we welcome conversations about revising this language. And finally, our facilities are aging. A modern detention center and replacement for Spring Mountain Youth Camp are long-term needs to ensure safe and therapeutic, developmentally appropriate environments. Some promising practices. I wanted to mention that despite these challenges, Juvenile Justice Services, juvenile detention was recognized for high performance and innovation in 2025. Director Flores also mentioned the Medicaid reentry process that we're undergoing. So I'll skip to operational changes have reduced the detention population, shortened stays, and lowered probation caseloads. Diversion practices continue to develop and evolve through the Harbor Consent Decree and improved juvenile probation intake practices. And our school justice partnership is being redesigned to reduce unnecessary referrals and keep youth connected to education. I want to thank you again for your continued support of Clark County youth and families. We remain committed to transparency, collaboration, and effective service delivery. I'm happy to answer any questions.
Thank you so much. The questions from members here in Las Vegas. I don't see any, so we'll go to Carson City and remote. Any questions? All right. I just have one question. Since we talked with Washoe County about some of the trends that they're seeing, I know that we didn't ask you in advance to compare your presentation, so I just was curious if you've noticed any similar trends with girls being admitted, or sorry, girls needing supervision and those person offenses.
So I think for Clark County, we see it, but we just see it in bigger volume. So in addition to everything else, I think a lot of the charges that we see mostly are battery. I would say that battery DV are probably our highest misdemeanor charges that we see. With regard to crimes against persons, I think we see a lot of, for felony charges, we see battery again, probably. And I would probably say robbery with use with a deadly weapon is probably our highest felony charges that we see. With girls, there's always a lot more complexity that we have to address. And there's a lot more risk as well. I think our boys and girls both share a lot of commonalities with risk and supervision needs in the community, but placing girls is very difficult for us. So creating that pivot point placement has been very helpful. There's two parts of it. One is a 90-day program for those kind of transitioning that are just looking for a place that can be transitioned quickly within 90 days. And the other one's a 6 to 9 month program for girls that need a little bit more support, a little bit more help, that have essentially no other options within Clark County. And so just identifying placements that are willing to take girls and also just overarching supervision needs. It's very difficult. And unfortunately, some of those kids, when there isn't a placement option available, end up spending in a lot of time either in detention or in Clark County's Child Haven for foster care services and CPS. So trying to avoid those placements where they don't really need to belong and try to find a quality program in the community is what we're looking for.
Thank you so much. I think those are all of my questions. I don't see any other questions, so thank you so much for joining us today. We will move now to agenda item number 7 and hear from the Department of Corrections. Oh, actually, Mr. Munoz, it sounds like we might have one more question for you. Assemblymember Hanson, did you have a question?
Yes, thank you, Chair. I'm sorry. I texted, oh, never mind, because I know you're trying to juggle a lot of down there. But thank you. Real quick, just to follow up on the Chair's question in relationship to young women, and you mentioned that it's more difficult at times to place the females. And I was just curious if you could elaborate, what are some of the barriers that we have in those placements? Just looking to see if we can find any solutions in the community with that.
John Munoz for the record. I think that probably with the most difficult problem we have is just being a flight risk. Some of our girls, when we place them, run very quickly. And sometimes there's a tendency to want to put a GPS monitor or some kind of tracking system on them to try to maintain a placement or at least know where they're going to run to. However, we have some providers in Las Vegas that will take a foster care placement or JJ placement in the community in group homes, but there's not that many, and those homes fill up pretty fast. So when we talk about putting girls in placements, I think last year there were 74 placements that we did for girls in the community. And it doesn't seem like a high number, but those, for lack of a better phrase, frequent flyers that we do have, those placements get burned out very quickly. And so the search continues for another placement where we can try to be more successful, wrap more services around them, try something different. Unfortunately, there's just not a lot of options. I think all the jurisdictions throughout the state suffer with the same resource availability that we do. I think it's just our volume is a lot higher, so it's a little difficult.
Thank you for that. I think it is helpful, especially for those of us that might not be interacting with these systems. We kind of really need to know what you're up against, what these young women are up against, and the entire system. So I appreciate you helping us to try to understand these challenges. So again, thank you to all of you for what you do.
Indeed, thank you so much. All right, looks like we have our representatives from the Department of Corrections at the table in Carson City, so I will hand it over to you whenever you're ready. And we also have representatives here in Las Vegas. Sorry. Welcome to all of you, and please go ahead.
Good afternoon, Chair and members of this committee. My name is Emily Testweed, EMILYTESTWUIDE, and I am the Deputy Director of Programs at the Nevada Department of Corrections, and here with me is Warden Henley of the Northern Nevada Correctional Center. Thank you for having us here today to present on the housing of youthful offenders. The Nevada Department of Corrections has historically looked upon our juvenile population in the same programmatic lens as we have our adult population. Although adjudicated as adults, these juveniles still require services that are designed to target their individual needs and at a higher level of service. Best practices for youth in adult correctional facilities combine 4 key elements. One is housing the youth separate from the adult population with steady and trained staff dedicated to support the program by tracking, monitoring, and addressing behavior through a graduated sanctions incentives level system. 2, provide structured programming to include cognitive behavioral therapy, education and vocational training, substance abuse treatment if needed, trauma-informed care, and pro-social recreational activities limiting idle time. 3, risk need responsivity-driven and individualized case planning, assessment, and targeted interventions. 4, continuity of care either to a more structured adult unit through mentorship and continued education, vocational training and programs, or through family reunification reentry planning to include employment, housing, stability, and continued treatment if needed. Although we have separated them from the adult population and provided them with mental health treatment, access to programs, as well as tablet-based programming and educational opportunities, the fact is that this population requires a higher level of support, services, and oversight that we did not have the infrastructure, staffing, or funding to fully implement. The NDOC started this process by moving this population from a rural location at Lovelock Correctional Center in Lovelock, Nevada, to Northern Nevada Correctional Center in Carson City, Nevada. This was primarily done in order to provide increased access and collaboration with local community service providers to support this population. However, we have since realized that our program model and service delivery is adequate, but lacks the internal infrastructure, staffing support, and services needed for implementation of these best practices. We reached out to the Nevada Division of Child and Family Services to learn more about the assessment tools they utilize, the graduated sanctions level system they implemented for behavior modification, and the programs and services they provide in an effort to increase engagement, decrease institutional misconduct, and improve overall outcomes for the youth housed in the facilities through their release back to the community. In discussions with DCFS and other partners, we found that we needed to completely reimagine how we conduct and utilize assessment tools and provide programming and offer structure and support to this population in order to be successful both while incarcerated and post-release. Through this exploration and self-assessment process, we realized that additional funding would be required to support these necessary and positive changes. As a result, we allocated additional funding through Title I-D to a level which encompassed much more than our previous funding levels to accomplish. This additional funding will allow NNCC, Carson City School District, Carson City Adult Education, and correctional programs the capability to provide not only designated staff to support these youthful offenders with structured programming from the start of their day until the end, but to also incorporate consistent assessment tools, evidence-based programs, training, and processes utilized by our partners at DCFS and in line with best practices. Our designated staff will consist of a forensic casework management specialist as well as a program officer. The forensic casework management specialist will lead a multidisciplinary team They will ensure the administration and data collection for youthful offenders literacy assessments for appropriate placement and educational programming. They will provide individualized case planning, coordinate and ensure program delivery, and will stand up and maintain a level system. This position will also support the future creation of a specialized program housing unit for our 18 to 24-year-old population. The program officer will support transitional services in the form of job placement assistance, interviewing skills, resume writing, and continuing enrollment in education continuum, either in high school diploma, post-secondary, or vocational assistance to obtain industry-recognized certification and support family reunification efforts upon their transition or future release. Our collaborative efforts with CCSD, CCAE, DCFS, and other community partners will help us create a program that has the capacity, capability, sustainability, and infrastructure to provide the much-needed evidence-based, trauma-informed, and specialized support critical for this unique population. I have some numbers to also share. From January 1, 2025 to present, we've had 32 youthful offenders housed at NNCC. 21 since January 1, 2025 have transitioned out to other facilities. 3 remain housed at NNCC with the adults, and 4 have been released from our custody, and 7 are currently still under 18 and housed in the youthful offender unit at NNCC. We have had 10 youthful offenders graduate with a high school diploma, again, since January 1, 2025. We have had 2 female offenders housed at Florence McClure since January 2025, and we have 1 still housed, but ages out April 22nd, 2026. She received her high school diploma while with us, and we also have had 1 female who has transferred through Interstate Compact, and once she turned 18, she was returned to their custody. And then we have just a look at our average daily population from 2020 to 2026. For Florence McClure, 2020, ADP 0, 2021 0, 22 0.1, 2023 0.5, 2024 1.2, 2025 1.4, with an overall 0.6. And then at NN Lovelock, starting back from 2020, average daily population was 12.4, 2021 was 11.9, 2022 16.7. And NNCC starting in 2023, average daily population was 10.9, 2024 17.8, 2025 9, 2026 9. And we are available for questions, or unless you wanted to add something.
All right. Do we have questions here in Las Vegas? Okay, questions online or in Carson City? Okay, I had one clarifying question. I'm sorry, I think you said this at the very beginning, but how many youthful offenders are in the department's custody right now?
8. 7 male, 1 female, under 18.
Okay. And did you also tell us how many people are currently in custody who began as youthful offenders and have since turned 18?
Since 2025, but we can definitely get that number.
I mean, I would guess it's only a handful since you only have 8 youthful offenders. I'm just curious. But if there are no other questions, I think that covers it. All right, thank you all so much for being here. We really appreciate it. And I think that brings us to the conclusion of our presentations on juvenile justice issues today. So we will be switching gears and hearing from the business law section of the bar. And we welcome you up to the table now.
Chair, I do believe we have a Zoom link that was distributed, so I don't know if you can see the Zoom on your end. Rob Kim will be joining on Zoom.
Yes.
Perfect.
We see him now.
Thank you so much.
Thank you. I want to confirm that I can be heard.
Yes, we can hear you.
Great. My name is Robert Kim, ROBERT-KIM, here in my capacity as chair of the Executive Committee of the Business Law Section of the State Bar of Nevada. My apologies for not being present in person at one of the hearing sites, but I'm currently out of in another office of my firm. I want to thank you, Senator Scheibel, and the members of the committee for giving us the time to present on behalf of the State Bar's Business Law Section. Generally speaking, we're going to give a brief update as to our efforts and what we're looking to do in 2027. That being said, you may have heard a lot more news about Nevada corporations and entities being highlighted in the news, being considered over other states like Delaware and Texas. And I feel as though, even though there's been a lot of recent spotlight, it's a product of a long-term effort by members of our committee, as well as prior members of the committee and prior practitioners in Nevada, to provide a framework for people to take advantage of Nevada's business laws and to find Nevada as the right situs for their operations as well as their corporate needs. It all began in 1991 when there was a substantial overhaul of Nevada's corporate statutes, where it was a combination of the Model Business Corporation Act and other influences from other states. And in every session since that time, every legislative session since that time, the business law section has had a bill presented to the legislature for purposes of incrementally adopting clarifications and improvements to our business laws, corporations, LLCs, and otherwise. And so through the cooperation of the various sponsors throughout the years, we've been able to present to you those amendments that have been designed to improve our laws from a clarity perspective and from a utility perspective for users. In particular, last year's bill was important to have been approved, and we appreciate everyone's efforts on this call to help get that done. Last session, we had AB 239 that was approved and did two major things. One was to kind of clarify the fiduciary duties of controlling stockholders and to provide a safe harbor for certain transactions involving them, as well as allowing a corporation to adopt certain waivers of jury trials in their articles of incorporation, trends that were in the news and were addressed by other states as well. So our timing was very appropriate. In terms of the overall effort, we know that we are just a mere part of this vast ecosystem of being a business-friendly environment. Nevada Secretary of State's office has released some key metrics to just show you the magnitude of what's happening with Nevada. As of December 31st, in that month, that is, there are almost 7,000 business formations in the month of December of 2025. And the Secretary of State generated about $20 million in business licensing fees in that month. In terms of the most recent snapshot in the month of March 2026, over 8,000 new business formations were filed in Nevada, and there's a generation of about $20.8 million of business licensing fees in March of 2026. So the impact of this ecosystem, I don't think can be understated, and we appreciate everyone's efforts to continue to maintain Nevada as a place where people prefer to do the business and incorporate. In terms of 2027, we thought we would just highlight for you a few things that we are looking at doing. As we do every session, we have a series of amendments that are designed to be more clerical and are designed for consistency purposes. So we are focusing on, and with a little more specific intent, to eliminate any inconsistencies throughout the various chapters for similar concepts. Want to make sure key terms are used in a way that avoids confusion. And we want to clarify that LLCs under Chapter 86 can be used for any lawful purpose, be it profit or nonprofit. There has been a use or a desire to use LLCs for nonprofit purposes as well. In addition to some of the clerical items that we typically look at, in terms of some of the substantive areas that we are planning to look at, they include the following. The first is to assess whether we should have some limitations, subject matter limitations on stockholder proposals and or minimum ownership requirements to submit stockholder proposals. This is mainly in the public company context. We feel as though maybe having some controls will allow a corporation to be more efficient in using its resources and cash in terms of managing the stockholder proposals that it does receive. We thought we also clarify what internal actions means. Currently, internal actions are those actions that deal with the rights of stockholders of corporations or fiduciary duties. And the use of that definition of internal actions relates to the ability of the company to be able to establish an exclusive forum for hearing those matters, typically in the state of Nevada, or typically in the business courts thereof. We want to make sure that the ability to use the term internal actions is consistent with other federal law claims that sometimes are part and parcel of some of those claims. And so we just want to clarify that for future use. We also want to look at stockholder agreements generally, make sure that those limitations are currently reflect current use. We also want to think about whether a corporation may adopt in its articles of incorporation a lower standard to remove a director. Currently, Nevada is notably requires a 2/3 vote of stockholders, 2/3 of the voting power to remove any director. And so most states do not have that. So we're entertaining whether we should have an amendment to our article, the ability of a stockholder, a corporation that is, to adopt an amendment or to adopt in their articles that provision to allow a lower, but definitely more than a majority vote for the removal of directors. And we're also thinking about whether we should adopt or allow a corporation to adopt mandatory arbitration for certain stockholder claims relating to internal affairs or internal actions. And lastly, lastly as it relates to corporations, is whether we want to have certain limits or certain ownership requirements for a stockholder to file a derivative claim. Texas has notably adopted a 3% beneficial ownership requirement for any derivative claims to be brought. And it has developed a lot of thought on this, and we haven't decided whether it's a good idea or not for Nevada, but it's something that we will be considering only because there's been a lot of discussion of that Texas provision. And then lastly, for LLCs, we're considering whether we should adopt a plain meaning provision to Chapter 86. There is a plain meaning provision in Chapter 78 currently that instructs those using the state's laws and interpreting the state laws to derive the plain meaning from the statute and not to infer that which is not intended to be inferred. And so since Chapter 86 is typically a chapter where we defer to the parties to enter into their own contract, we thought that it was appropriate to consider whether a plain meaning provision should equally guide Chapter 86 as it does currently for Chapter 78. And lastly, one area is to further clarify the fiduciary duties in LLCs and to make sure or to ensure that there is clarity as to what LLC fiduciary duties are in place when there is no statement of what fiduciary duties are in the operating agreement. So that just meant to highlight the things that we are considering for the upcoming session and for the upcoming bill. And myself, I may be available for questions, as well as the co-chair of our section, Albert Kovacs, who is in the Las Vegas hearing room as well. Thank you very much.
Thank you so much. All right, are there questions here in Las Vegas? We'll start with Assemblymember Marzola.
Thank you, Chair, and thank you for your presentation. I'm not sure who can answer this. I can appreciate that we can look at other business-friendly states such as Delaware or Texas to see what's working, what's not working. You know, we always say Nevada is a little different. And so how do we know what's working in Delaware or Texas is actually going to work here?
I can take that question. This is Albert Kovacs, Vice Chair of the Executive Committee of the Business Law Section of State Bar Nevada, ALBERT KOVACS for the record. When it comes to looking at other states, the committee never takes anything verbatim. Our perspective is that what works in Delaware or Texas or Maryland or any of the other states that are kind of competing for corporate formation business don't necessarily work in Nevada. So just because something does work in Texas or Delaware, we don't assume that it will work in Nevada. We look at what's working in other places, or in some cases, what isn't working in other places, and say, how does that fit or not with the overall policy objectives of the business laws of this state and its constituencies? And overall, not to speak too much for the committee, so I'll speak for myself. The goal and the perspective is to have our state's laws be clear and comprehensive and comprehensible, thus the plain language provision that Mr. Kim just mentioned that's in our corporate statutes, so that the full range of our constituencies have access and the ability to utilize our statutes in a way that is meaningful. So whether you're starting your first business out of your garage and forming a single member LLC, or you're the CEO of a publicly traded company or a startup that's getting ready to go public, you can look at the laws as they are written and adopted by the legislature and have a pretty darn good idea of what the law is in the state, and you don't need to go through decades of case law. You don't need to, in some cases you're still going to need to hire a lawyer, but you may not need to consult them as much because you can read the words on the page and understand what they mean. That's always our goal. In terms of other policy changes, for example, I think Texas is probably leading the way. Like, for example, the ownership threshold requirements to file a derivative action. Generally, that's just for folks who may not be familiar with the term, a derivative action is when a stockholder brings a claim on behalf of the corporation, generally saying that the board isn't doing its job. In some cases, those actions are very well justified and appropriate. In other cases, they're brought for nuisance purposes or to collect settlement fees for lawyers. And usually the tell for those is that the named plaintiffs in the class action own a very, very, very small percentage of the company. So while Texas may have a good policy reason for raising that threshold and say it's not just own a share of the company, it's own a fairly noticeable stake, 3%, that policy may not be right for Nevada, given who uses our statutes and how they use them. The 3% may not be appropriate. That may be too high. And so whenever we look at these things from other states, we say, should that kind of requirement be automatic in our statute, or should that be something where companies could opt in? Should that only apply to publicly traded companies versus non-public companies? So that's kind of the thought process that we go through. We never reflexively adopt something just to keep up with the Joneses. That's never our approach.
Thank you, Chair. Thank you for that very thorough answer.
Other questions here in Las Vegas? I'm not seeing any, so we will go to Carson City and remote. Any questions? Okay, we're going to come back down to Las Vegas for Senator Wynn.
I know that through the state bar and the business section, you vet the, potential pieces of legislation, not only through like these smaller committees, working groups, and then it goes to the full committee, and then I think it goes to the state bar. When will you have those recommendations fully vetted through that process?
Robert Kibb again, as chair of the business law section. Generally, the state bar issues a legislative calendar of deadlines for submission. We have not received that specific calendar as it relates to the upcoming session, but typically we would expect that by the beginning of the summer, we would be, let me take a step back. So we already prepared, obviously, the high level concepts, and we're in the process of preparing the actual language. There's a deadline and during the summer where we submit a draft amendments to the state bar, and then that is distributed to the other section chairs for any issues or concerns, where if there are any, they're reconciled and then finalized and then submitted to the state bar board of governors for their assessment and their one of their meetings where there's a question and answer session as well for the board of governors. That usually concludes around August or September of the even year, so it's coming up. And then once that is done, then we typically seek a sponsor and get our proposed amendments submitted for a bill draft. So that's the general timeline. So I would expect that we would know what we plan to be submitting by early fall.
The only reason I ask is I know that committee bills, like we're obviously soliciting ideas for committee bills, and obviously the chair have you present in here. I think there's like some interest in what you guys are all working on, but I know our deadlines for a committee bill submission is September 1. So for what it's worth, we would probably like to be able to see some of those recommendations even before, and I see your government affairs person out in the audience as well, and I know she's very well aware of those deadlines as well, so I just have you keep that in mind as well.
Thank you, we will.
I have one question. You had mentioned that substantively, one of the things that the section is considering is clarifying in law that an LLC can be used for a nonprofit. Could you just talk a little bit about why that would be or how this came up?
Yes, Robert Kim for the State Bar, chair of the executive committee. That point was raised by one of our committee members, and it was something that that member of our committee had received a few questions on from different sources. And so I think as part of our thought process is that there, and others in the committee had noted that there had been kind of one or two requests as well. So I think for our purposes, we thought it was important to understand how it's being used in other states and whether or not this is something that we want to add and have Nevada have the capability or clarification on. Currently, entities are allowed to be used for any lawful purpose. And so I suppose arguably one could say that a nonprofit is a lawful purpose. But I think just to provide certainty, if we thought that was appropriate to adopt, we would adopt an amendment to the purpose section and to allow and to clarify that it can be used for both profit and nonprofit purposes. So it's something that has come up in practice for some of our members of our committee, and we thought it was a sufficient enough request to see how it's being used and whether it's appropriate for adoption in Nevada.
One additional point here, Albert Kovacs, Vice Chair of the committee. Somewhat speculation because I haven't seen this done in practice, but I think some of the distinction arises. The reason we have profit corporations and nonprofit corporations is because of the rigidity of the structure of that entity form. So a corporation has a board of directors and stockholders who are the owners and the derivative claimants at the end of the day of the assets of the corporation, which isn't permitted generally at least for a 501c3 nonprofit, which is what I think most people are thinking of when they say nonprofit. So we have a different type of corporate entity under Chapter 82 that is specifically designed for nonprofit purposes, where that flow of resources doesn't leave the corporation. It doesn't go, there's no owner of a nonprofit. So there's no equivalent to a stockholder. The LLC form is much more flexible and like Mr. Kim already said, already contemplates the ability of having non-economic members. So I think because of the prevalent use of LLCs, especially within larger organizations, they may want to have the flexibility of ensuring that they have the ability within their nonprofit structure to have an LLC if that makes the management structure more efficient. And so we just want to make sure that if we're correct in understanding the motivation for that there is that flexibility within Nevada's LLC statutes to allow that to occur.
Okay, thank you. I appreciate your answer. Any other questions from our members here? All right. We really do appreciate, oh, sorry. Thank you. Senator Krasner, please go ahead.
It's okay. It's okay. Thank you, Chair. I just a quick follow-up on that question regarding the LLC. Would the LLC still have to file the application for recognition of exemption under Section 501c3 of the Internal Revenue Code, or what are you proposing, please?
This is Robert Kim, Chair for the Business Law Section. Yeah, this point would only relate to state law. So for all other purposes, I would expect that entity to still apply for 501c3 status with the IRS. I don't think that would change at all. Even whether it was the primary entity or the supporting entity, in either instance, that entity should still seek the current expectation of having the proper federal exemptions.
Thank you.
All right, thank you again. And that brings us to the conclusion of agenda item number 8. And agenda item number 9 is our second opportunity for public comment. Anybody wishing to give public comment in person is invited forward in Las Vegas and Carson City to do so now. I do see somebody coming forward in Carson City. We will start up there. Please try to limit your comments to about 2 minutes and go ahead when you're ready.
Okay. Tanya Brown, TONJABROW, and Advocates for the Inmates and the Innocent. Good afternoon, Chair Scheibel, members of the committee. I'd like to reiterate what my colleague Anne-Marie Grant said earlier, and how much we truly appreciate being given the opportunity to submit our recommendation to the committee for consideration. We are waiting for a response, and once we do that, we'll submit the recommendation along with the materials. But in the meantime, I was listening to the juvenile justice, and as I was listening, I was looking up some information, and I just want to let you know what I found. So here we go. As I was looking at the states with the strongest, I have to take my glasses off, I can't read, strongest recertification protections. These states are considered the national leaders because they use development principles. Top tier, Hawaii, Vermont, Connecticut, New Jersey, Colorado. These states strongly limit adult prosecution of youths, make reverse transfers easier, require judges to consider brain development, provide strong treatment, family-based services. States that have the strongest juvenile specialty courts: California, Texas, Florida, Ohio, New York, Pennsylvania, Colorado, Massachusetts. And mental health, two other states would be Washington and Oregon. And Nevada is considered to be the medium tier. So I think maybe we might want to look at the top tiers to get some of this information. From what I was reading, they answered some of the questions you were asking. So just a thought here. Thank you, and have a good day.
Thank you so much. I don't see anybody else in Carson City, but I do see some folks here in Las Vegas, so please go ahead.
you guys doing? Ali Porter, for the record, OLIPORTER, CEO and founder of Words Are Rich Foundation, a nonprofit organization here in the state of Nevada. A lot of what we heard today is amazing in terms of just ideally, certifications and having a decision working with the youth. So we have a program here in Nevada where we work with the youth ages 12 to 25 specifically on reentry as well as at-risk causal factors, foster system care, homelessness, where we have current partnerships here with like CASA, CPS, different things like that, where we're still going through the county certification process and things like that. We're a new foundation here. A lot of our experience comes from personal lived experience. So I'm formerly incarcerated. I did over a decade in prison myself, but I also boast a BA in psychology and different things as well. So both the education and lived experience perspective, a lot of what we heard today with different counties here in Nevada that are struggling with the program sector, right? Having programs that offer certain things that would help within some of the decisions that were being made here. So I'm just here showing my presence saying, hey, my name is Ali Porter, again, with Words Are Rich Foundation, CEO and founder. How can I help? Thank
you. Good afternoon. My name is Angel. I know it's been a long day for you guys, so I'll make it quick. I wasn't going to speak today. I was just going to listen. And as someone who was certified as a juvenile at the age of 15, I just had to say something. I spent 20 consecutive years in the Nevada Department of Corrections. And I just want to share a little bit about what that looks like for someone. Obviously decisions are being made about that. So I think it was important for me to share. I don't remember the certification process. I had like a maybe fourth grade reading level. I didn't understand the process. I ended up pleading guilty because I wanted to take responsibility and walked out of there with 2 life sentences. And as of today, I'm still on lifetime supervision, and that hinders me from getting jobs. Even the contractors board said they would not allow me to have a license, a contractor's license, because they consider that an open case. These are things that someone who gets certified will most likely go through, because if you're certified, that means that you'll probably get a lengthy sentence and you'll end up in an adult facility at the Nevada Department of Corrections. And a lot of things were mentioned about being housed separately. I was also in youth called the YLP Youth Offender Program, but the influence is still there from the adults, regardless of whether you're put in a corner somewhere or not. And you do age out. I remember on my 18th birthday being aged out and sent, to the adults. And I've done that. When I was arrested, I was in Clark County with adults. I was not segregated or anything like that from day one. So I can tell you from my experience, that is a thing, and then it does play a big role in how you rehabilitate yourself. I know gangs were mentioned a lot. I'm not a gang member. Never had it. My crime was not gang related. But when you are in an adult facility, gangs is a part of life. Certain phones you cannot use. And this is something that a lot of these youth will go through, whether you're in juvenile or you're in an adult facility. So gangs, you might not be a gang member, but you will conform, or, you can lose your life or use your imagination on that. It can be horrible for you. So like I said, I wasn't going to say nothing. I just wanted to be a fly on the wall here today to see how I can advocate for the youth, because this is what I do. I'm the director of youth advocacy because I believe in that in my heart, and that's my passion. That's what I will be doing for the rest of my life. With that being said, I hope I brought some insight on what it looks like to be certified as an adult and help the decision making or whatever the process may be with you guys. So I appreciate what you guys are doing. It's wonderful. I am encouraged by the conversation today about different programs and things like that. I really appreciate your effort. Thank you.
Thank you so much for being here and for sharing with us. We appreciate it. And, it's not easy. So, okay. All right. I don't see anybody else coming forward for in-person public comment. We'll go to the phones, please, for public comment.
Thank you, Chair. If you would like to provide public comment, please press *9 now to take your place in the queue. Again, to provide public comment, please press *9 now to join the queue. Chair, our public lines are open and working, but there are no callers for public comment at this time.
Thank you so much. That brings us to the, thank you. I think that is the end of that agenda item, brings us to the end of our meeting. For those of you who are new here, there is also an email address on the sign-in sheet. I encourage you to send us an email and get it included on our list so you get updates on future meetings. And that's also how you can get in touch with us if you have questions or need any further follow-up. I think that's everything. We do not have a meeting in May. Our next meeting will be on June 16th. Be on the lookout for an agenda, and not seeing anything further, we are adjourned.